Justice, sabi ni Justice, kailangan po pagtalunan. Nag-aayos. Mang naman. Andito lang. Andito na po. Andito na po. Good morning, ladies and gentlemen, and welcome to Day 2 of the National Decongestion Summit, a conference to unlock solutions to jail and prison overcrowding. Once again, I am Laura Cruz Herrera del Rosario, Deputy Clerk of Court and Judicial Reform Program Administrator from the Supreme Court Program Management Office. I'm also the Judiciary Representative to the Core Secretariat of the Justice Sector Coordinating Council, or the JSCC. The JSCC is behind the events yesterday and today. So from day one, from the opening ceremony down to the last parallel workshops, we have been very productive and the discussions have been fruitful. Self-serving po on my part to say it, but I am sure you have also been discussing among yourselves your individual experiences, tama po, and personal highlights as you went through yesterday's sessions and workshops. You know, ladies and gentlemen, this was not an easy summit to prepare for. It took us years, some decades, to get to where we are today. And yesterday we had key takeaways. And my key takeaway is this: in order to win, you have to lose. So this maroon girl standing in front of you wants to congratulate LaSalle for its basketball win yesterday. For our resource persons, the Filipinos love basketball, and we had the university championships yesterday, and I thought I was going to lead a cheer today for my fellow Maroons, Universidad, but I will not be able to do that. So I lost a bet and I'm wearing green today, but next year we will win again. Thank you. That is the takeaway from the National Decongestion Summit na itawid ko talaga. Okay. We are happy to announce yesterday, Justice Arcega and Justice Musngi announced the logo making contest. Ito po, sa likod ng rehas, panibagong bukas. You know that the winners of the logo making contest received their award already. The award was delivered, the prizes, cash prize po ba ito? Groceries, nasa picture kasi. So may we flash the documentation from the BJMP Office of the Directorate for Welfare and Development. We would like to thank our partner from the EU Justice Sector Reform Program, Governance and Justice, for the arrangements for the prize. I'm still waiting for the photo of the handover of the groceries to the winning artist. Siya po yung nagpa-testify. Ayan po. Hindi pa pala binigay sa artist. Sa BJMP pa lang. May iba pa ba tong documentation? First prize. Ayan. Ang daming groceries sa BJMP. Okay. Please vid in the artworks. Okay, so dahil po dyan, I will proceed to the recap, the real recap of yesterday's session. My recap was very personal, including highlights. Let us welcome back to the stage our GOJUST experts on decongestion, jail decongestion, prison, and nasal decongestion. Attorney Romel Abitria of the Humanitarian Legal Assistance Foundation, to be joined by Dr. Raymond Narag of the Southern Illinois University. Thank you.
Hello. Hello. Good morning po. Thank you, Attorney Elia. I think some members of some participants here, Attorney, are indifferent as to the result of yesterday's game. The blue ones. Pwede na rin po. Anyway, good morning sa lahat, and Our summit yesterday was opened with the messages of support from DOJ and DILG, as well as from the different development partners. Then they were followed by the very encouraging messages from our Chief Justice, the Speaker of the House of Representatives, and the Senate President. In his speech, Chief Justice Esmundo declared that the JSCC is committed to reduce admission, increase releases, and expand jail facilities and capacities. He said that the success in decongesting jails depends on close cooperation, coordination, and collaboration across the 5 pillars of the criminal justice system. But for me, as an academic and a worker in the criminal justice system, I think it's a statement that the efficiency and efficacy of any criminal justice system is measured not by how many are prosecuted and incarcerated, but rather by how many are reformed and rehabilitated, is a much-needed light for the 5 pillars of the criminal justice system that clarifies the purpose not only of incarceration and punishment, but of the criminal justice system as a whole. Speaker Romualdez's commitment to support the following crucial legislative reforms was also most welcome. So he enumerated the following bills as priorities: the review of crime classification, diversion of adult offenders, the Department of Corrections and Penology Bill, law on reintegration and psychosocial rehabilitation, the amendment of the current Recognizance Act, and then the strengthening of the Commission on Human Rights to act as the national preventive mechanism against unjust incarceration. For his part, the Senate President acknowledged that this summit is a step in recognizing the fundamental human rights, that fundamental human rights apply to every Filipino, including PDLs, no matter the crime, no matter the sentence. He said that the PDLs may deserve commensurate punishment for the wrongs that they have committed, but they are still human beings who deserve the opportunity for growth and change. Of course, we heard the Executive Secretary affirm that what we are doing here today aligns with the administration's priority to decongest jails and prisons, to enhance the efficiency and effectiveness of the criminal justice system. He reaffirmed the commitment of the entire government to expedite criminal cases and alleviate chronic problem of jail congestion. And then we presented our study, followed by Justice Singh's discussion of the jail decongestion concept note, where she discussed the proposed short-term and long-term activities. Among the short-term proposals were to amend Rule 114 of the Rules of Court, increasing the threshold in preliminary investigation and inquest, reviewing and removing arrest targets and quotas for law enforcers for specific offenses, enacting the rule on women in conflict with the law, reinforcing sector and agency-based monitoring mechanisms for the release of PDLs, integrating jail decongestion in the CLEP, and strengthening the night courts. To end the plenary session 1, Ate Lori moved us as she shared her experiences with the criminal justice system. So as the plenary session ended, we proceeded with the workshops. For workshop 1, Senior Associate Justice Leonen presented the concept of the rules on writ of kalayaan as a transformative judicial remedy aimed at addressing the complex issue on prison and jail congestion. He described it as a concrete, creative, and pragmatic solution. Deputy Director General Pereiras of UCOR responded by emphasizing the needs for standard in character assessment, release mechanisms, and criteria for evaluating inadequate detention conditions under the proposed rule. But for the part of Jail Chief Superintendent Moreno of BJMP, he expressed optimism that the writ of kalayaan would facilitate a holistic government approach to tackle jail congestion. For workshop 2, Ms. Charis Domingo presented the initiative of Silicon Valley DILG, a community-based effort to help people facing charges by engaging the community. DILG, through its volunteers, is able to impact the outcome of cases by employing a unique approach in the cases referred to it. One of the notable practices of DILG is the use of mechanism known as participatory defense, best exemplified by the creation of social biography packets for PDLs to give light to their character from the perspective of their families and friends. For Workshop 3, Attorney Lailani Banotan of BGMP shared that only 32% of the BGMP jails have libraries, and she emphasized the necessity of establishing libraries in jail, not only to expand the knowledge of the PDLs, but to give them opportunity to avail of the good conduct time allowance, thereby giving them the chance for early release. Ms. Esteban from the National Library committed to connect the jail libraries to different local libraries. For Workshop 4, the discussion centered on the use of digital systems, such as the Justice Data Lab of BJMP Regional Office 10 and the Detainees Information System of the La Union Provincial Jail that kept track of the PDL's data or information to ensure that they do not overstay inside the penal facility. The creation of Task Force Katarungan at Kalayaan in Pasig City was likewise proven to have hastened the reduction of unnecessary detention by cooperative efforts of the justice sector actors. For plenary session 2, we heard the Honorable Associate Judge Gabriel de Silveira Matos shared some good practices from Brazil, including what the Federal Court termed as an unconstitutional state of affairs within the Brazilian prison system brought about by overcrowding. He also discussed Brazil's National Council of Justice Initiative, the Fazendo Justicia, or Doing Justice program to mitigate overcrowding and jail congestion. Associate Justice Salameda highlighted the need to calibrate the Philippine framework through the JSCC, which is a joint and concerted effort of the three branches of government. While Jail Senior Superintendent Roy Valenzuela of the DILG pointed out that custodial hearings would be an effective filtering mechanism to weed out unworthy cases clogging the court dockets. Lastly, IBP National President, Attorney Antonio Pido, entertained the possibility of adopting the concept of collective petitions for habeas corpus in the Philippine legal setting. For Workshop 5, both panelist judges shared their challenges when they inherited hundreds, if not thousands of cases when they were appointed to their courts, and shared their best practices and techniques that helped them manage and declog their courts. Judge Falcon created a system where he classified cases into 3 categories depending on the status of the cases. On the other hand, Judge Solidum Taylor gave several tips in determining probable cause and highlighted that the key for expediting cases is for the parties to enter into complete and comprehensive stipulations. She also suggested coming up with templates for court orders and resolutions. Attorney Asis from PAO said that the PAO expressed its cooperation in the decongestion program by assigning 1 PAO lawyer for every court. While OIC Senior Deputy State Prosecutor Decena Valdez agreed with the importance of stipulations and added that the prosecutors are encouraged to be proactive in insisting on stipulations in their cases. For Workshop 6, Jail Senior Superintendent Valenzuela of the DILG gave a comprehensive overview and evaluation of the decongestion programs implemented by the pillars of the justice system in the Philippines. He discussed the current status of the programs and an extensive enumeration of potential solutions and alternative modes of restorative justice. There was a rich and productive discussion as participants from PNP and the CHR gave their insights and practical suggestions to address the overpopulation in the jails. For Workshop 7, retired Judge Lianderal said that the potential of a clinical legal education program has to be seen in the context of the justice system in which it operates, or the local context. She said that there is a need to rethink and reshape the approaches to drug policy reform because of the increase in the volume of drug cases filed in the past few years, totally different from the intent to deter crime. Attorney Deginod of San Beda University shared how the college students in the Junior Bedan Law Circle facilitated the release of PDLs through their jail decongestion activities. Attorney Pido then mentioned that a solution would be involving law students through CLEP integration in each IBP chapter, where an IBP lawyer would be a supervising lawyer. Lastly, for Workshop 8, the panelists discussed the different good practices in their respective areas in their respective areas. Judge Formaran of JSCC Naga shared the best practices spearheaded by the Justice Zone, specifically the Transparency and Accountability Board, or the TAB. The TAB shows the performance of the actors in the criminal justice system. According to Judge Formaran, the efficiency of the criminal justice system increased because of the Transparency and Accountability Board. For her part, Executive Judge Poblete showcased the Balangas Justice Zone Premier Program, which is Bataan Cares. It is an aftercare program for the PDLs in Balanga City. As emphasized by Judge Poblete, this rehabilitation program seeks to end the vicious cycle of PDLs. Balanga Justice Zone was able to engage the local government, both the city and the barangays, especially the local anti-drug abuse councils, to support the rehabilitation of persons who use drugs. Lastly, Executive Judge Fuentes of Davao City shared a good model of institutionalizing and sustaining the local justice zones and its projects. She shared that the Davao City Justice Zone, through the help of a Sangguniang Panlungsod member who is a member of the Justice Zone, advocated for an enactment of an ordinance defining the rights of PDLs according to the Nelson Mandela rules. The JSCC also developed a manual which provides a comprehensive guide to implementing and managing social protection programs and services for PDLs and their families. Now, I would like to ask Dr. Raymond Narang to give his insight on what happened yesterday. By the way, thank you to the Supreme Court PMO for the documentations.
All right, thank you very much, Attorney Iyog, for that comprehensive summary of what was discussed yesterday. Okay, so indeed, marami po tayong napag-usapan kahapon. We were in the different workshops, and we even provided more inputs in those workshops. And I'm a professor, and usually what I do in the very start of the class is, so what have you learned from previous sessions? All right, so let's check. In the framework that we provided in this summit, the way to reduce our jail congestion, would be to look at it from what we call the C2 perspective, right? So we look at capacity, and capacity is a function of three factors: input, throughput, and output. Input simply suggests that these are the people coming into our system. The more input, of course, there will be overcapacity. Throughput is how long they stay in the system. And the longer they stay, of course, it will lead to overcapacity. And finally, output. Output is how many people gets out of the facility. And of course, if there are many output, then it will reduce input. And vice versa. If there's few output, it will lead to very much congested facilities. And it also a combination. Even if you have very many output, right? For example, the Bucor releases as many people to our communities as soon as possible. But if there's also more input because of the police arrest and prosecutorial charging, then all those output could be overrun by your input. And we also said that there's also a very simple way to solve the problem. Just expand capacity, which means to say, build, 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 build. And it happened to many countries in the world. But that's a short-term solution. Why? Because if you build, they shall come, right? It's like a field of dreams. And so, you might have a very good jail now, but a year or two or so, because you have some vacancy, then it could lead to more input, and then that vacancy will then later on be filled up. Does that make sense? Hello? All right. So here's what we're going to do. Let me just ask, if you really paid attention to the discussions, whether the things that we discussed yesterday could be considered an input, a throughput, or an output. First, the discussion by Justice Leonen on writ of Kalayaan. Input, throughput, or output? Any thoughts? Who says it's an input innovation? Throughput innovation. Output innovation. Oh, all right. It's an output. Why? Because according to Justice Leonen, if the place of congestion is dehumanizing, it's overcrowded, it's substandard, then we have to release people. Or we could temporarily halt the admissions of people in those facilities up until those facilities are not yet fixed or are not yet up into standards. So I would say it could be an output intervention or it could be an input intervention. Huwag mo na kayong magpakulong hanggat hindi kaya ng ating capacity. Does it make sense? And in the United States, they do that. They would say, hey police, hey prosecutors, don't put more strains in our jails and our detention facilities because we are full to the brim. In fact, in the United States and in many other countries, if a jail is overcongested, they could say to the judge, Judge, even if you are going to commit me a new detainee, I will not accept. Because if there's something that will happen to that detainee, it's the jail warden who will be held accountable. It's not the judge. And so in the United States and many other countries, once their facilities are full, they have the right to say no to admissions. And we call that moratorium. There should be a moratorium right now in the Bucor. Why? Because the Bucor is full to the brim. The Bucor should not admit new admissions at the moment. Why? Because if anything happens to inmates in the Bucor, it will be the Bucor who will be held responsible. Okay, so that's like an idea of the writ of Kalayaan. Does it make sense? All right. Workshop number 2. The justice zones. All right, so input, throughput, or output? The justice zones, they coordinate, they make sure that they identify who are the people overstaying, they try to work on those cases so that they will be released early or they will be disposed early. Input, throughput, or output? Throughput. Very good. So there are many ways for us to improve the efficacy of our system through coordination. One of the things in our research is many of our hearings are postponed. Why? Because there are some judges that set hearings like 20, 30, 40, 50 hearings in a day. Isa lang po doon ang matuloy. Dalawa, what happens? Postpone po yung iba, reset. Lack of material time. But if there will be good coordination between the actors and they prioritize who will be heard today, let's just set 5 or 10, and all of those hearings will be pushed through, then BGMP will save so much resources. Why? Because BGMP, when you ask them to bring the inmates for a hearing, they will put everything in their power to bring that inmate to court. Transportation costs, security costs. Unfortunately for the BGMP, all their hard work of bringing the inmates to the court will be for nothing when it gets postponed. Tama po ba, BGMP? Kawawa po tayo. Tama ba? Pag na-hearing ang postponed. So if there will be coordination and it will facilitate the disposition of cases, that will be a throughput innovation. All right. Question number 3. Clinical legal education. Input, throughput, or output? Any thoughts? Who says clinical legal education, input, throughput, or output? Innovation. Throughput. In what way? Well, it's because if individuals know their rights, they could fight for it. Many inmates, what we found in our research is they don't even know that they have a right to post bail. They don't know that they have the right to file for a motion for adoption of bail. And what we found in their study is that when inmates do not invoke these rights, the PAO lawyers sometimes do not invoke it as well. And if the PAO lawyers do not invoke, then they don't invoke it also to the judge. And so the judge may not be prodded to action. And so there are many people in our jail study that says they've been in jail for 6 years, they are bailable, but they could not afford to trust the amount of bail, but they have never tried a reduction of bail. Is that true, Sister Tess Gomez of the Preso Foundation? Very true. So again, if you have a clinical legal education, and then you inform the detainees of their rights, they could be prodded to initiate their own interest, and then probably they could be assisted by our legal practitioners, like the lawyers or student practitioners who could help them assist in the preparation of their own defense. All right, my friend Cherise from the United States, participatory defense. Input, throughput, or output? It will be input. Why? Participatory defense basically says that if you are an accused, then you have a community who would support you, gather social historical background about your character. And if you deserve to be out, then you don't have to be put in detention because of your character. So it minimizes the input. How about alternatives to case disposition? Roy Valenzuela. So if you divert cases, it will be an input reduction as well. All right? So many of the things that we did yesterday, though they are disparate because we came from different initiatives and backgrounds, we could integrate them all together using this framework. Last slide, please. And in summary, if we could actually reduce the input, we could expedite the throughput and maximize the output. What happens is that we rationalize our criminal justice facilities, right? Meaning to say, we use detention as the last resort. We reserve our limited space to the most deserving. Only those who are hardcore, all those who are likely to recidivate, those who are likely to flee from their court appearances. Yun lang po ang ilalagay natin sa kulungan. But first-time offenders, low-risk offenders, they should be out and released through supervision. And we could say that we need to be evidence-based. And so there are efforts to digitalize and computerize all our case managements. In the long run, if we follow that framework, our jail system and our prison system will be more focused, it will be more rehabilitative, eventually it will lead to less cost, and then it will increase public safety, and overall, the society will improve, right? Because there will be an increased trust in our legal system. So this is what we have done yesterday, and today will be a full day as well. And so please, as you try to discuss many of our initiatives in the workshops, think along these lines. Is it reducing the input? Is it maximizing the throughput? Or it's also maximizing the output? And hopefully, the stories that we heard yesterday, like Ma'am Lori's, will never be heard again, right? That we have a better system that trusts, that cares, and empowers. And for me, as I've told again earlier yesterday, I am Raymond Narag. I was once a client of the system. I was in jail for 7 years as well, accused of a crime I did not commit. But I use my experiences as a learning experience, and I use it to empower our own criminal justice system. And I'm very proud, before we are doing this in the wilderness, now all of you are here echoing and sharing all the things that we are working forward. And eventually, it will benefit us all. So thank you, and hopefully we have a meaningful second day.
Thank you very much for that recap, Attorney Abitria, my blue friend, who was probably busy doing the recap, that he did not see that his blue campus in Katipunan actually turned green. So hindi po neutral. Now, that is the true spirit of sportsmanship. I'm sure if UP had won, the Church of the Jesu would have turned maroon. Sabi ko lang yon. And of course, Dr. Narag, who is maroon, by the way, and has been fighting this fight. I have seen the losses. I have seen the pains. And today, I am sure Dr. Narag is very, very happy because we are in a summit. Remember, there were times we were in the wilderness. So congratulations to all of us for making it this far, but we have day 2 because we have a lot of work ahead of us. We will just have a simple change in the program because we wanted you to focus on your sessions continuously. Yesterday, we heard a lot of policy decisions, we heard a lot of institutional promises, but we all were touched by the lived-in testimony of someone who, like Raymond, experienced this in person. So today, we have a similar experience to be shared with us, but this session will again be moderated by Mr. Martin Perfecto, whom I will call back on stage. Sir?
Ako na naman. Hello? Pwedeng taasan? Salamat. So, I will continue the joke about colors. So, attorney, I'm also another blue friend, as I'm in blue right now. But believe it or not, I'm also green. So anyway, so that joke didn't catch. Anyway. So it's me again. Sa pangalawang araw, tulad ng kahapon po, magsisimula ngayong araw po natin muli sa kwento ng isang dating PDL. Kung kahapon po, si Ate Lori ang nagkwento, ang magkukwento po ngayong umaga ay bibigyan ko una yung buong pangalan, si Ismael Pasawilan. O di kaya, sa madaling salita, si Kuya Sammy. Si Kuya Sammy po, ngayon po ay isang pastor. Okay. Pangalawang punto po, siya po, nagsimula po ang kanyang pagkabilanggo noong 1985. At lumaya po siya mula sa Bilibid noong 2009. So, gawin po natin ng matematika, humigit kumulang po 24 na taon po siyang nabilanggo. At yan po ang magiging siguro puso ng kanyang kwento ngayong umaga. So, Kuya Sammy?
Magandang umaga sa lahat. At salamat sa Panginoon dahil binigyan ako ng pagkakataon na makapagsalita sa inyo upang ibahagi ang ginawa ng Diyos sa ating buhay. Noong mag 3 months ako na isinilang ng aking magulang, dahil ang aking nanay ay Maranaw, ang aking tatay po ay Cotabataan nyo. Ang ibig sabihin, puro akong Muslim po. Hindi ko alam na iningi ako ng kamag-anak kong commander at inalagaan ako sa kanyang kamay. Ang ibig sabihin, wala akong alam kung sino ang tunay kong mga magulang. Nang nag 7 years na ako, meron pong mga taga-ibang bansa na nagtuturo na kailangan pumatay ka para makarating ka sa langit. Sabi ko, ang ganda ng turo nito ah. Maliban doon, lalo akong natuwa dahil pag namatay ka sa firing line, dahil naging MNLF ako noon, sa ilalim ni, kilala ninyo siguro, si Normo Sari. At sabi niya, pag namatay ka, tiyak, sa langit ka pupunta, mayroon ka pang 5 anghel na magiging asawa. Sabi ko, ang ganda nitong turo ah. Sabi, nung ako po ay nagkaedad, wala akong alam sa edad ko kasi hindi ko rin alam kung kailan ako sinilang, siguro nasa mga 16 o 17 years old ako niyan, mayroon akong mission order na ibinigay sa akin sa Guinar Santos City. At doon ko nakilala yung kapatid ko at doon ko rin nakilala yung mga magulang ko kung sino. At sa madaling sabi, noong panahon na yan, 1985, ay may mission order ako doon. Yung kapatid ko naman, nahuli. Nahuli siya noong panahon na yan. At sa madaling sabi, pinuntahan ko po yung nakahuli. Sabi ko, bakit inuli niyo ang kapatid ko? Hindi lang po yung kapatid ko inuli, pati ako inuli na rin. At sa akin, sa pag-uli sa akin, ay pinipilit nila sa akin na ilabas ko yung mga baril. Kasi sabi niya, ikaw yung pumatay sa ganito, ikaw ang umambos ng ganito, ikaw nagkarnap ng ganito. At sa madaling sabi, binugbog ako ng gusto. Sabi ko, Hindi naman ako makapagsalita ng gusto dahil sa panahon na yan ay hindi pa ako marunong masyado magtagalog. Kasi ang salita ko alam lang ay Maguindanao o Maranao. Lalo ako nila binugbog. At mayroon dumating na isang bus na pinipilit na ituro ako ang mga kumplinan. Sabi ng mga kumplinan, ng mga kinakausap nung nakahuli sa akin sa barracks, ay sabi niya, hindi yan ang muka ng gumawa sa amin ng pumatay sa aking mga kamag-anak. Pinipilit. Sabi niya, kung hindi mo palabasin yan at kung hindi nyo kakasuhin yan at hindi nyo yan ituturo, 24-hour, pwede na siyang lumabas dahil walang kaso. Sabi nung nag-interpret sa akin na opisyal na marunong mag-Muslim, ay halos binugbog ako ng binugbog gusto. Dahil gusto nila aminin ko yung kaso. At dumating po sa panahon, mayroong dumating na dalawa po, kinabukasan, na pinailan ng kaso. Yung mga kaso na pinail sa kanila, ipinail na rin sa akin, bali 4 kami. Ang ibig sabihin nyo na ay, kinasuhan ako ng hindi ko nagawa. Sabi ko, dapat ang kaso sa akin rebellion. Bakit? Ang tanong ko sa sarili ko, bakit tinasuhan niyo ako ng murder? Illegal possession of firearms, carnapping, robbery highway, mga iba-iba pa mga kaso, robbery with homicide. Hindi ko na mabilang yung kaso na ikinaso sa akin. At iyon ang dahilan kung bakit ako po ay napunta sa loob ng kulungan. At nung nasa kulungan ako, lalo po ako nabugbog. Dahil may batas po doon sa barracks na pag bago kang pasok, bubugbugin ka. At doon bilangguan, doon ko dinanas ang lahat ng hirap. Dinanas ko ang napakaliit na pagkain. At mayroon kami kasabihan, nung panahon yan, ay hindi ako kumakain ng baboy. Sabi ko, mas gusto ko pang uminom na lang ng tubig. Lalo ako naghirap dahil wala makpakain. Maliban doon, napakasikip ng igaan. 3 buwan maigit akong minsan nakatayo na tutulog. Minuto lang magigising. Minsan nakaupo, nakatulog. At kung mayroon pong pagkakataon na makaiga kami, yung paa namin nakaganon. At pag nabaluktot mo yung paa mo at papalitan ng isang paa, hindi mo na maituwid yan. Yun ang napakahirap na dinanas ko doon. At maliban doon po mga kapatid, nung nasa loob ako ng Bartolina dahil hindi ko matanggap na nakulong ako, lahat ng mga ginagawa na nasa loob ng kulong, ginagaya ko. Yung mga bagong bilanggo ay kinukuhaan ko ng gamit para pangsugar lang o makabili ng pagkain. Ganun ang ginagawa ko doon hanggang sa dumating po na mayroon mga jailbreak, puga, sumasali ako doon. At isa ako na Bartolina. At doon sa Bartolina, nagpapasalamat ako sa Panginoon dahil sabi ko, mayroong ginamit ng Diyos na isang pastor na napakakulit. Na sabi niya, kailangan mong makilala si Jesus. Sabi ko, paano mo pakilala sa akin si Jesus sa isang tao lamang yan? Paano ako ililigtas ng isang tao? Pangalawa, paano ako mapatawad sa aking mga kasalanan? Ang dami kong nagawa na pagkakasala. Sabi ko sa kanya, kung mapapatunayan mo na mapapatawad ako sa kasalanan ko, pwede ko siguro tanggapin yung sinasabi mo. Alam nyo, ang kino sa akin, Isaiah chapter 1 verse 18. Sabi niya, halik kayo, magliwanagan tayo. Sabi ng Panginoon, gaano man kapula ang iyong kasalanan, sabi niya, handa kong paputin. Gaano man, sabi niya, karami ang iyong kasalanan, handa kang patawarin ng Diyos. Sinlaki ng barko ang iyong kasalanan, sabi ng pastor na ito, sinlawak ng karagatan na ang papatawad ng Diyos. Sabi ko, ngayon ko lang narinig yan. Sabi ko, paano yan? Sabi ko, kayo, kaaway ko. Paano ako mapapatawad yan? Sabi niya, may tinuro si Jesus. Dating, kapuutan mo ang iyong kaaway. Ngayon, sabi niya, mahamahalin mo ang kaaway. Sabi ko, bagong turo ito ah. Bagong turo ito, kakaiba ito. At sa kakulitan ng pastor nito, alos araw-araw pinupuntahan ako sa Silda o sa Bartolina ko, ginigiit niya ang pagbabago ay magmumula kay Kristo. At sa madaling sabi ay doon ko tinanggap yung sinasabi ng pastor na ito. At sabi ko sa pastor, Diyos, sabi ko, hindi kita kilala. Pero patunayan mo, pag nakalaya ako dito sa Bartolina, paglilingkuran kita. May ginamit ng Diyos na taga-Red Cross, International Red Cross. Tinanggal ang tanikala sa paa ko at yung pusas sa kamay ko. At doon ko napatunayan na ang Diyos ang nagpalaya sa akin. At nagsimula doon yung pagbabago ng buhay ko. Sa madaling sabi, 1992, dinala po ako sa National Beloved Prison. At lalo ako nahirapan doon dahil sa RDC pa lang ng pagdating namin noon, ganun din ang nangyari sa akin. Natutulog ako sa CR na nakatayo. Wala nang matulugan sa dami ng bilanggo na nakakulong. Ganun din ang pagkain. Gusto mo pang kumain na madagdagan, wala kang idadagdag dahil wala kang dalaw. Dahil taga Mindanao po ako. At sa madaling sabihin, pagkatapos ng RDC, dinala ko sa maximum security compound. At doon sa maximum security compound, kapatid, ganun din ang naranasan ko. Kulang din ang pagkain. At may kasabihan doon, baboy nga ang pagkaluto. Ay baboy nga ang ulam, pero baboy ang pagkaluto. Baka nga ang ulam, bito baka sakali kumakain mo. Ganun ang buhay doon. At doon ko naranasan, mahabang taon ng aking pangulungan, bihira lang ako nakaranas ng dalaw. At salamat sa Panginoon, dahil nung pinalaya ako ng Panginoon, doon sa maximum security compound, 2009, at nung paglaya ko, wala po akong kilala dito sa Manila, dahil ayaw ng aking nanay na mag-uwi pa sa General Santos City. Nagsapalaran ako sa Manila. At alam niyo po, dinanas ko po na inaakit ako ng mga kakilala ko na nakalabas na. Sabi niya, sumama ka na dito. May diskarte kaming kikita ka dito. Pero alam niyo po, pinilit kong magpakahirap na dahil wala akong mapasukan na trabaho, dahil wala akong iskumbik ako, wala akong pinag-aralan, no skill ako, wala akong alam sa trabaho. Ang pinili ko na lang para pagpapatuloy ang pagbabago po ay namulot na lang ako ng basura. At doon sa pamumulot kong basura po, nagpapasalamat ako dahil sa bawat pulot ko ng basura, nakakain kayong magkapatid. At sa madaling sabi po, ako po'y nagpapasalamat dahil noon itinuturo sa akin ay pumatay ka para makapunta sa langit. Pero ngayon, ang itinuturo ko naman sa tao bilang lingkod ng Diyos ay si Kristo. Sumampalataya ka kay Kristo at magkaroon ka ng kaligtasan. At hindi ka lamang magkaroon ng kaligtasan, mababago ang buhay mo. At salamat sa Panginoon dahil ang kulungan ginamit ng Diyos sa akin. Dati impyerno ang bilangguan sa akin. Dati parusa sa akin ang bilangguan. Pero ngayon, ang masasabi ko sa bilangguan ay papasalamat ko dahil hindi parusa sa akin, kundi ito po ay pagpapala. Kaya yun po yung kwento ng buhay ko. Ako po ay lubos na nagpapasalamat sa lahat na ito at maraming salamat po sa inyo lahat.
Maraming salamat po, Kuya Sammy. Gusto ko lang bigyan ng pansin isang punto na sinabi niya. Actually, yung huling sinabi niya, ulitin ko na lang. Yung lakbay, no? Magmula nung ang kwento niya sa akin, yung kwento niya, nagsimula yung pagtuturo sa kanya na kung magpatay ka, may gantimpala nung 7 years old lang po siya. No? Yung lakbay na nagsimula doon at yung lakbay niya ngayon na parang kabaliktaran ng una niya natutunan nung 7 years old siya. Pero bilang pagtatapos, hindi lang yung kwento po ni Kuya Sammy, kundi yung kwento rin ni Ate Lori kahapon. Ang tanong, magandang tanong siguro sa sarili po natin, tulad ng mga iba't ibang, mga libo-libo pang ibang lumaya tulad ni Kuya Sammy at saka ni Ate Lori. Ang tanong po, ganito kaya din ang kwento nila? Dagdagan pa po natin yan. Sa humigit kumulang po na 200,000 na kasalukuyang PDL, ganito rin kaya ang kanilang mga kwento. Kung ang sagot po sa matanong na ito ay oo, siguro yan ang dahil kung bakit tayo nandito ngayon. No? Sa unang araw, kung pag-uusapan po natin ang mga tugon sa mga kwento nila, kahapon po nagsimula tayo sa ano-ano, sinasagot na natin tanong, ano-ano yung tugon? Kahapon po nagsimula na po tayo at umaasa ko siguro matulad ni Kuya Sammy at ni Ate Lori, ngayong araw magpapatuloy yung pagsagot sa tanong ano-ano yung tugon. At saka sa madarating pang siguro mga araw, linggo, buwan o taon. So maraming salamat po.
Maraming salamat po, Kuya Sammy at Mr. Martin. Pagkatapos po nun, hindi ko na po kayang magbiro. Diretso na po tayo sa next session. For this session, for the first workshop today, it is my honor to introduce the moderator for the session on input reduction for decongestion, reviewing law enforcement and prosecution practices. The moderator will be Associate City Prosecutor Mariel L. Francisco from the Department of Justice. Attorney Mariel, please.
Thank you po, Attorney Lara. Good morning, everyone. I'm Associate City Prosecutor Mariel Latorre Francisco, your moderator in this plenary session 3, entitled Input Reduction for Decongestion, Reviewing Law Enforcement and Prosecution Practices. So may I call the 3 panelists, Yusek Andres, Major Consina, and Attorney Bernardo to kindly occupy the seats on the stage. The goal of this plenary session is to focus on the case build-up and revised performance indicators for law enforcement. So our first speaker will be focusing on the issues of decongestion and DOJ reform programs. He completed his Bachelor of Arts in Economics and his Bachelor of Laws from the University of the Philippines. Presently, he is serving as the Undersecretary in charge of the Law Enforcement Cluster of the Department of Justice, including the National Prosecution Service, National Bureau of Investigation, and the Anti-Money Laundering Council. Likewise, he represented the Philippines in the United Nations together with Justice Secretary Jesus Crispin Sirimulla during the International Convention on Civil and Political Rights Revalida in Geneva, Switzerland. Let us give a round of applause to our first speaker, Undersecretary Jessie Hermogenes T. Andres.
Good morning, everyone. I had a prepared speech for this morning, but having heard Kuya Sammy, I think I will digress from my speech and address point per point the matters raised by Kuya Sammy. Napakaganda po ng naipaliwanag nyo dito at palakpakan po natin si Sammy na napagtagumpayan niya ang napakalaking pagsubok. Just the first slide first. DOJ reform programs, achieving a common vision. I'm very happy that this event finally took place after years and years of collaboration and coordination this event finally took place. I am very confident that this is already a success for everyone. I have been in practice for 33 years as a lawyer. And only in the last 10 years, probably I could say, so many justice reform programs finally implemented. I have to commend the present Supreme Court. So many reform programs have been implemented only in the last 3 years. In my whole career as a practicing lawyer, I have begrudged the system because it did not provide remedies that were needed by the people that it's intended to serve. But here and now, I believe all the stars have aligned. This Justice Sector Coordinating Council has finally come to fore and have brought all the possible solutions to the ills of our justice system. And I believe at the end of this exercise, we will come up with concrete resolutions and action points such that everything would be in order with respect to the Philippine justice system, not in the long future, but even in the near future, even before 2028 ends. I believe all of these things in the pipeline will probably converge into a new paradigm that we can call an ideal system for our country. Let me explain, next slide please. Let me explain the interactions between the 5 pillars of the criminal justice system in relation to Kuya Sammy's plight. As we all know, there are 5 pillars in our criminal justice system. It starts with law enforcement, the prosecution, the judiciary, the corrections, and of course, the community. First and foremost, why was Sammy subjected to all of this inhuman treatment from the very beginning? Why was he framed to answer for crimes he did not commit? This is the fault in our system, where law enforcement agents were probably not guided by the correct standards in law enforcement. The justice system, the Department of Justice, has in its logo, justice for all. But this present administration has a different dimension to it. We call it compassionate justice. And we include the primacy of human rights in criminal justice administration. Central to every act of the Department of Justice is the observance and protection of human rights. Nothing of that sort would have happened to Kuya Sammy if all of these precepts were observed by the law enforcement agents and the prosecutors at that point in time. Hence, a major shift in the policy of the DOJ was constituted when we issued Department Circular Number 20, which is the proactive cooperation and involvement of the prosecutors together with the law enforcement agents. Previously, there has been a divide between the prosecutors and the law enforcement agents. The prosecutors would be there passively accepting evidence that the law enforcers may submit to them. And they will just sit there like judges and pronounce whether this is sufficient to file a case in court or not. That system will not work. And that system is based only on the existence of a mere probable cause, that a person should be charged in court and held to answer for a particular offense. That has to be changed. And indeed, through the Justice Sector Coordinating Council, these discussions were made, and eventually we issued DC-20, which is a paradigm shift where the prosecutors and the law enforcement agents will now partner with each other to gather correct evidence, to gather and charge people of crimes they actually committed based on evidence properly gathered, consistent with the dictates of human rights and the rules of court. Next slide, please. What have we identified as the major issues in our justice system? Two things, all of us know this: court congestion and jail congestion. And these two matters can be addressed simultaneously in this new circular that we have provided. This year is the 75th anniversary of the Universal Declaration of Human Rights. And indeed, if there is one most important right under the Universal Declaration of Human Rights, it is the right to life and the right to liberty. There are so many rights under the Universal Declaration that includes even the freedom of expression, freedom against the ill effects of climate change. But lo and behold, over and above all of these rights, right to life and right to against deprivation of liberty would be most paramount. And that is also provided under Article 3, Section 1 of our Constitution. No person shall be deprived of life, liberty, or property without due process of law, nor anyone be denied the equal protection of the laws. So now our present correction system is being evaluated and questioned. We have prison facilities all over the country. However, as you all know, they are congested to the hilt. It is just so heartbreaking to hear a story, the story given by Kuya Sammy. But to us, it may only be a story, but to him, that was a gruesome reality for decades. Can you imagine? We feel so fortunate that we are here, comfortable in this hall, and probably we have no relatives in prison. But how about those people who are in prison presently? Who will take care of them? Who will look after their welfare? This government was supposed to look after their welfare. And sad to say, we have miserably failed up until now. All the ills that Kuya Sammy described are still there. But happy to say that with this congregation formed and with all the initiatives of the Justice Sector Coordinating Council, solutions are at hand. And I'm very confident all of these solutions will be in place because we all know that we have the whole of government approach dealing with this matter. I'm very happy to note and announce that we have support from Congress. The regionalization of prisons is a thing that will happen because it is fully supported by Congress. And I'd like to take the opportunity also to acknowledge the full support and leadership of the Speaker of the House, Speaker Martin Romualdez, who was funded and assured us of the continuous funding of this regionalization of prisons. Of course, that is not the real solution, but it is also an immediate need for us to implement the regionalization of prisons. Kuya Sammy was saying he had no visitors for the several decades that he was incarcerated. What motivation would we have to reform if you do not even have any family member supporting you? But indeed, this regionalization of prisons will address that matter because prisons will be put in those areas where the prisoners hail from. And that will give them encouragement to do what is necessary for the correction and reintegration into society. And that is something that is already in the pipeline and will be implemented soon. Next slide, please. These are all the prisons that we have presently. Other than the New Bilibid prison, we have 8 other prison facilities. The Correctional Institution for Women, the Davao Prison and Penal Farm, the Institution for Women in Davao, the Iwahig Prison in Palawan, the Leyte Regional Prison, Sablayan Prison in Occidental Mindoro, and San Ramon Prison, and Penal Farm. But these are still few prison facilities. And with the regionalization, almost all the regions will have prison facilities because ideally there should only be 3,000 inmates in a particular prison compound for proper management. And so the welfare, the health, the food rationing of the PDLs would properly be addressed in a situation where prisons are regionalized and organized in 3,000 PDLs at one compound. These are statistics. Next slide, please. We jotted all the additional PDLs as input coming into these prisons throughout the year 2022, and we have an additional 8,700 to what was originally 30,000. And for 2023, next slide, we also jotted 8,400 new PDLs coming in. So you can imagine how much more congested it will be. Narinig ko na po yung istorya na yan, but coming from Sammy himself, it broke my heart. I always give this an example. We have a 320% congestion rate. You can imagine a facility for 10 people, but 32 people are inside that facility. I think what Sammy described is even worse, where they cannot even have a place to rest their feet. Now, how do we see things moving forward? We have also gotten these statistics on the informations filed in court, meaning new criminal cases. We have a total of 327,000 cases last 2022. And in 2023, so far, we have 246,000 new criminal cases. And with the lifespan of these cases, let's say, even on the average resolved in 3 years' time, you can imagine an influx of 100,000 new PDLs a year. And that will really exacerbate the situation unless we do something about it. Can you just up the mic, please? Now, the solutions. We are now reviewing law enforcement and prosecution practices. First and foremost, we have crafted a comprehensive DOJ reform program consisting of various facets. And this is something that the Filipino community maybe doesn't know yet, and maybe we should take time to discuss these things amongst our stakeholders when we go back to our constituents. This is a comprehensive reform program that I believe will address everything. And again, I give credit to the Justice Sector Coordinating Council for making possible all of these discussions. First, in order to put primacy to human rights and to do away with the practice of filing haphazard cases, flimsy cases, cases that have that do not have sufficient evidence, we have to increase the cooperation between the law enforcement agents and the prosecutors. Before, we just have to file a case because there is probable cause. And what has that resulted into? Just clogged courts. Clogged courts. No more hearing dates sooner than a month. 2 months' time is the nearest hearing date from one hearing to the next, simply because the courts are clogged. But why are the courts clogged? Because our threshold of evidence needed to file a case is just probable cause. It's a flimsy amount in a scale of 1 to 10, probably 3. And why have we done this matter and consistently done it through the years without anybody lifting a finger to point out this is the wrong way to do it? Now we are facing it squarely and biting the bullet. We are changing the quantum of evidence that is needed before a case should be filed in court. It is now prima facie evidence with reasonable certainty of conviction. Yes, that is needed because that is the right thing to do. Why will you deprive a person of liberty if there is no sufficient evidence at hand against him? That is what we have been doing for decades and decades, resulting into this mess. We just keep on filing cases without even ascertaining whether this will lead to a conviction. But now we have a different policy. Before a person could possibly be charged in court, there should be more than sufficient evidence to prove all the elements of the crime. And it is the prosecutor who will certify to this in cooperation and coordination with the law enforcement agents. Hindi na po pwede mangyari yung nangyari kay Sammy na magdidikta, na magfe-frame ng tao ang paggawa ng kaso dahil ang prosecutor po ang mananagot. Kapag sinabi niya na merong sapat na ebidensya, sinasertipika niya na ang ebidensya nito ay nakuha sa tamang paraan at supisyente para magkaroon ng conviction laban sa taong sasampahan ng kaso. At kung hindi po siya sapat na ebidensya, he will have to issue a certificate under his oath as a prosecutor, and he will be held accountable under the Prosecution Integrity Board if he does not perform his duty to make sure that the evidence is at hand, and he certifies that there is reasonable certainty of expectation that this case will lead to a conviction. That is the new thing that will happen in the implementation of this new circular, and the Supreme Court has already agreed to this in principle. And in fact, we are just awaiting the final promulgation of the amendment of the rules of court, specifically Rule 112 on criminal procedure, that will adopt the new procedure and will give DOJ the prerogative to handle preliminary investigation with no judicial interference. And that is why I indicated there the judicial policy of non-interference, which is enshrined in the Supreme Court decision that it is only an executive function determining the probable cause or the need to file a case in court. And that is the basis of our rules of criminal procedure that eventually the DOJ will promulgate, and that will now enshrine this new threshold of evidence that will now limit the number of people charged in court to those where case buildup has been completed, and the evidence will now lead to a reasonable certainty of conviction. That is the big game changer. You know, in my practice, what is the reason there are so many acquittals in court? Because precisely evidence is being gathered while the case is being presented. Why is this the case? Evidence should be gathered before a case is filed in court. And that is now the system that will be in place. Next slide, please. What are the other inputs, so to say, reduction measures that we have in place? So now we believe that really the number of cases will dramatically fall. But that doesn't mean that we are not going against offenders. We are building up the case in due time so that when they are ripe for filing in court, we will do so. Because it was determined in a study that even for bailable offenses, people still stay in jail. You know why? Even for bailable offenses, why are people still in jail? They simply could not post bail. It was learned that if the amount of bail exceeds 10,000 pesos, those people charged even with bailable offenses will stay in jail because they could no longer afford any bail on top of 10,000 pesos. Maybe they could borrow money from relatives, but not to exceed 10,000 pesos. Hence, this bail reform is institutionalized under Department Circular Number 11. And again, thanks to the Supreme Court, there is an administrative order on the process of recognizance. This is another means by which a person can be released and not detained during the course of trial. Recognizance is a procedure with the approval of the court where a person can be granted provisional liberty while trial is being conducted on recognizance of a person of good reputation in the community who will assure the attendance of the accused during trial. And this is a matter that is already provided in the law and has already been implemented by the Supreme Court in its circular and is now presently being cascaded to all prosecutors. You know, even if there is a law, there is an implementing rule, you have to take the effort to cascade it to the lowest level of the bureaucrats, including the prosecutors in the trial courts, because they have to be apprised of this and encouraged to avail of this under the new policy. Otherwise, it will not happen. And that is exactly what the Department of Justice is doing in coordination with the DILG. We are conducting symposia all over the country. In all the 15 regions of the country, including NCR, we are conducting this massive campaign to inform all prosecutors and law enforcement agents on the new circular that there is now proactive partnership between the law enforcement agents and the prosecutors for this case build-up system. Now, other than that, what have we institutionalized? Automatic dismissal of cases. You might be surprised. Why would this be part of the program of the DOJ? Again, consistent with our understanding of human rights, why should a person be deprived of liberty? Why should a person remain in incarceration during the pendency of his case when we appreciate the case to be a weak case from the very beginning? So this automatic dismissal of case is a directive to all the prosecutors to review their inventory of cases and to determine whether at the end of the trial this will lead to a conviction or not. If the case will not lead to a conviction anyway, why are we still prosecuting it? We are only wasting the time of the courts. We are only wasting the time of the prosecutors and even of the witnesses, when at the end of the day, we know for sure that there is no sufficient evidence to lead to a conviction. So now, at the option, at the prerogative, motu proprio from the prosecutors, they will now file a case in court, file a motion rather in court for the dismissal of these weak cases to unclog the courts. And that is a matter we are also coordinating with the judiciary for that to be properly addressed. Of course, respecting the independence of the judiciary. And yet, as officers of the court, the prosecutors will now candidly declare, Your Honor, this case should be dismissed because there is no sufficient evidence against the accused. It will be in the prerogative of the court whether to acquit, grant a dismissal, but we will do our part as officers of the court, owing fidelity to the court. We will make this motion and make this happen so that half of these cases will readily be dismissed and resolved to acquittal, and that will really solve much of the cases that are clogging the courts. Next slide, please. Eventually, there will be, I pointed this out as an important input because 70,000 inmates are charged with drug-related cases. And we will have to review this law soon enough. The next big project will be the Drug Summit, where we will have a chance to review this law together with all the important stakeholders. And this will lead to amendments of the law so that less people will be incarcerated in relation to drug cases. While we are going against low-level offenders in a different manner, thank you. We will continue to be hard on big-time drug dealers and suppliers. Given our meager resources and the present state of things in the prison situation, next slide please. We have addressed jail congestion even with the manual review of records. And we have released, as of November 2023, 8,994 PDLs. Can you imagine this? 8,900 people who should not have been incarcerated anymore are still there. But now, with the review, they were able to be released because it was shown that indeed the offense for which they are charged is even less than the time that they have spent in incarceration. And we will continue to build up on the single carpeta system, the digitized version, so that the good conduct time allowance, the time allowance for studying, and special time allowance for loyalty can be considered in releasing prisoners. Next, please. Next. We have also included, very importantly, humanitarian releases. And I am glad to inform this body that only within this week, next slide please, we issued the Board of Pardons and Parole Resolution number 0802-2023, where people, PDLs, who are 70 years old, and even if they are high risk, if they have already served 10 years of their sentence, they shall now be considered for executive clemency, especially if they are suffering from old age, being sickly or terminal or life-threatening illnesses or other serious disability. This is a resolution signed only this week, and it is now being implemented. And a case in point is PDL Gerardo de la Peña, who is also considered a political detainee. There are two individuals here. 78-year-old Roberto Salvador, convicted of murder, having served 26 years, is now entitled to be granted and was granted clemency through commutation of service by the President, Ferdinand Marcos. Next. And here, I was referring earlier to Gerardo de la Peña, an 84-year-old. Can you imagine? 84 years old. Ano pa ho magagawa naman itong kaguluhan? Convicted of murder and is also considered a political detainee, but he was not entitled to be released under the old resolution. But now, because of this new resolution that instead of 15 years, it's only 10 years, he, having served 11 years, will now be entitled to be recommended for release under this new resolution. Okay, so finally, on my last slide, these are just the narration of the DC circulars. We have to perform our prosecutorial and investigative functions under a human rights lens. This is something that is not optional. This is mandatory, that everyone involved in prosecution and investigation should do their function properly under a human rights lens. And even as we pursue justice for victims of crime, we believe that it is not the number of cases that will be the real deterrent to crime. You can file 1,000 cases, but that will never be a deterrent to crime if there is no conviction. The real deterrent to crime is an effective criminal justice system that leads to a conviction after affording all individuals accused due process of law. Due process of law. And that is what we commit. We will reduce the influx of PDLs while observing the dictates of due process of law and mandate of effective human rights. Lastly, let me just end by saying I feel very safe this morning seeing all of the big high officials here in this hall. But I wish every Filipino could feel the same. Every Filipino should feel safe and secure in his own country. And this can only happen if all of us, all those involved in governance, put our acts together. And it is doable. Ladies and gentlemen, all of these are within reach and is doable. We thank all of our well-meaning sponsors and donors, the European community, the GOJUST, the Australian government, the UNODC, for their continued support. And I always say, you have not come at a better time than now, when all of these reforms will come to fruition. We hope for your continued support, and believe me, in partnership with you, we will reach our goal soon. Thank you very much. Mabuhay po kayong lahat. Let's do our jobs right. Thank you and good morning.
Thank you po, Yusek Andres, for that insightful presentation. Now let us hear the input reduction measures of the law enforcers. Our second speaker held key roles in the Philippine National Police, such as Chief Admin at the Provincial Public Safety, Provincial Chief of the Women and Children Protection Desk, and Chief of Police, all at the Camarines Sur Police Provincial Office. Presently, she serves at the PNP Human Rights Affairs Office as Chief Interagency and International Affairs Section. Let's welcome Police Major Judith Fajardo Consina.
Good morning po. Kinabahan ako kasi si Asek po yung nauna sa akin. So, good morning everyone. My task for today is to present the mandates and some functions of the PNP Human Rights Affairs Office pertaining to our persons under PNP custody, as well as the concerted efforts and initiatives by the PNP to alleviate the congestion in our custodial facilities. The PNP Human Rights Affairs Office operates within a defined scope, notably lacking the authority to conduct investigation. So we do not have po the authority to conduct investigation. We are only authorized to monitor our personnel who were allegedly committed human rights violations. However, our pivotal role involves vigilant monitoring of alleged human rights violations. To continue po, in addition, we consistently perform thorough custodial facility inspection to ensure that the persons under PNP custody are treated well. Next slide po. Ay, hello po. Okay po. So, to continue po, okay po. Okay. So, for my order of presentation po, the sequence of my presentation are as follows. I will address the challenges and problems associated with the management and supervision of persons under PNP custody. Second, the remedies and actions implemented to tackle these challenges and problems. Following that, we will highlight our best practices and finally, our ways forward. So, my slides po consist of pictures po, actual pictures from the different, supposed to be po yung presentation ko is, there are pictures showing the congested facilities po way back 2018 and earlier. But to 2018 and onwards po, kung makikita nyo po later yung aming action pictures po during our conducted custodial facilities to different police stations po, makikita po ninyo na napakalaki na po ng improvement. So as I go along with my presentation po, I can explain po ano po yung mga, what are the different initiatives we have taken to address that problems and challenges. For the challenges and problems, the PNP faces significant challenges in effectively managing and supervising our custodial facilities. These obstacles impact various aspects of our operations, including facility maintenance, coordination with relevant agency, and ensuring compliance with human rights standards. Addressing these challenges is pivotal to enhancing the overall efficiency and effectiveness of our custodial facility management. So the commonly encountered challenges and problems in our PNP custodial facilities include, number one po is yung congestion, followed by the insufficiency of food, insufficient for ventilation, complex and entangled faulty electrical wirings, poorly maintained or absence of toilet facilities, lack of funds for the transport of persons under custody, suspects that have been in the custody of the PNP, which require a court intervention for the disposition of cases due to lack of spaces in the BJMP detention facilities. The prosecutor and judge, instead of issuing a court order of the suspects, remanded back to the PNP the suspects for safekeeping, which is in violation of the rules of court. To continue po, these present additional challenges and problems that we are also currently facing naman po are the court allows the suspect to stay in the PNP custodial facilities beyond the reglementary period. So, ang supposed to be po yung mga custodial facilities namin ay temporary lang po siya, temporary. So, slow disposition of cases, unavailability of first aid kits and medicines for injuries and common illness, lesbians, gay, bisexual, and transgender inmates are incarcerated among the male inmates. Custodial officers of the police stations are only reliant to government hospitals, clinics, and health centers in cases of medical emergency, and it is only in instances when persons under custody are in need of medical attention that they seek the services of government physicians. The slow or delayed issuance of commitment order by the court, slow disposition of cases, inavailability to post bail by PUPCs, often due to excessive amount of bail, and lack of funds for the transfer of arrested suspects to the issuing court located outside of their jurisdiction. So we have also prepared po the present number of PUPC under our custody po. And as of November 20, 2023 po, we have a total of 17,429 po. And this was in different 17 regional offices po of the PNP, including our different units who are conducting the arrest, like po the Women's and Children, the Highway Patrol Group, the CIDG, the ABSE Group, the AKG. So, from all those units and regional offices po na may mga custodial facilities, we have only identified na meron pong congestion. And those regions were from Region 4A, the Calabar Zone, Region 7 po, Police Regional Office 7 in Cebu, and with the National Capital Region po. So, meron po kaming mga ideal capacity, but yun po yung basis namin, bakit na namin nasabi na meron pong congestion. Kasi we have our numbers po, kung ano lang yun po yung ideal capacity na kayang i-accommodate ng bawat custodial facilities namin. And for yung sa Krami naman po, yung sa WASI-PC po, kasi maliit lang po, so meron pong masasabi namin congestion kasi For the male and female po, the only kaya naming i-accommodate po is 10. But at present po, as of November 20, 2023, may 13 po. So may excess na 3. So our action taken po, yung mga nabanggit ko, most of them are solved na po. So I will further discuss what are the solutions. So we have undertaken numerous actions to address the problems and challenges encountered in our custodial facility. Our ongoing efforts aim to systematically tackle and resolve the issues at hand, ensuring a more effective and streamlined management of our custodial facilities. So in response to that po, the PNP Human Rights Affairs Office crafted a policy for the management and supervision of custodial facilities and the persons under PNP custody. Because our office have a mission that by 2030, we shall have fully institutionalized the respect for human rights as a way of life in the Philippines National Police. So, yung first action taken po namin is the issuance of the memorandum with subject decongestion of PNP lock-up cells dated August 14, 2012. So, decades na po itong aming memorandum na ito. And this memorandum was issued due to the alarming incidents of jailbreaks that transpired in some PNP detention cells way back 2011 po. One factors that contributed to the above-mentioned jailbreak is jail congestion, a problem which is prevalent in most of the temporary lock-up cells of PNP units and police stations. This happens when the court has not yet issued the corresponding commitment order. The continued practice of committing these prisoners under the custody of the PNP Custodial Center proved to be unduly burdensome on the part of the PNP because of the financial and manpower requirement it entails, and the fact that the said custodial center was established only to serve as temporary lock-up facility and to consolidate all lock-up cells of various operating units inside Camp Crame. It is not a long-term facility which can house number of prisoners like the facilities of the BJMP. For internally po, the PNP and its units have initiated various actions to tackle this issue comprehensively. We collaborate with the Supreme Court Administrator to expedite the issuance of commitment orders, hasten case dispositions, and explore alternatives like release on recognizance for minor offenses. Engaging lawyers to assist in drafting case resolutions, including a proposal requiring bar passers to aid in these processes before taking their oaths. Redeploying police investigators to expedite case filing resulting from law enforcement operations, allocating funds for the transfer of PUPCs to BJMP facilities, and exploring temporary transfer in the absence of commitment orders. Establishing a technical working group with the BJMP and DILG representative to address pertinent issues. Conducting regular medical checkups for PUPCs by the PNP Health Service and those who are in the local or in the respective local government unit. Our custodial facility are in close coordination with the local health unit po to help us to conduct the regular check-up of our PUPC in our respective AOR po. So, for the second action taken po, the implementation of a policy for the management and supervision of the PNP custodial facilities and persons under police custody or the PNPMC 2018-027, entitled The Guidelines and Procedures in the Management and Supervision of All PNP Custodial Facilities and Person under PNP Custody. The rationale of this memorandum po is to provide the comprehensive guidelines and procedures in the management and supervision of PNP custodial facilities and PUPCs in all Philippine National Police units. So, our purpose po is to set guidelines and procedures for PNP custodial officers and ensuring that persons under PNP custody are humanely taken care of according to the standard of the international human rights adopted by the Philippines and recognized by the PNP. For our third action taken po, we have also issued a fiscal directive. This fiscal directive shall apply to all PUPC who were arrested due to commission of crimes and those arrested under custodial investigation within the prescribed reglementary period. This subsistence allowance po is amounting only to 50 pesos and it will be allotted 1 PUPC 50 pesos po per day. And it shall be a charge against the Annual General Appropriations Act under Personal Services and subject to the availability of funds. So, yung pong, if ever na magkaroon po ng delay, yung mga respective, yung mga nasa police stations po, yung mga meron pong custodial facilities, so pinupunuan po muna namin. Hindi na po na kung meron magkakaroon po ng delay for the release of budget para sa mga PUPC. Hindi naman po namin ma-attempt na kumakain na yung mga polis, yung mga tao, lalo na po yung mga PUPC namin na walang bumibisita. So, ginagawan po namin ng paraan po yon. So, the Philippine National Police remains steadfast in its commitment to ensuring the humane treatment and upholding the individual rights of persons under PNP custody. To this end, the PNP conducts rigorous nationwide inspection and monitoring of custodial facilities, engaging the 17 police regional offices, headquarters support service, and other units under national support units. The primary objective is to ensure strict compliance with human rights standards, existing laws, and prescribed procedures and guidelines governing custodial facility management. This comprehensive approach is aimed at significantly improving the living conditions of PUPCs across the country. Next, please. So, for our recommendations, the following recommendations are suggested to help the PNP in crafting policies to better promote and protect the rights of persons arrested and under police custody. So, strengthening collaboration with the concerned government agencies, offices, and the Congress should enact measures to ensure the provisions of budget to the PNP to solely fund for the upkeep of persons under police custody. Among them is the most basic. The meals po, yung daily meals po nila, in fulfillment for the basic right to adequate food, the transport of persons under custody, maintenance and upkeep of the custodial facilities. For our second recommendation is for the PNP, BJMP, and the courts, concerned PNP offices, units to strictly undertake the following of directives. The memorandums issued by the Chief PNP way back 2012 po with subject decongestion of PNP lack of cells. When the case against a person under custody is already filed in court, the PNP unit concerned shall verify with the court whether or not a commitment order has already been issued. When the commitment order has not yet been issued by the court, the chief of police or the head of the PNP must write a formal letter request addressed to the clerk of court for the issuance of a commitment order to the BJMP of the place or territory where the prisoner is being tried. When the commitment order has already been issued by the court, the chief of police or head of the PNP unit must ensure that the person under custody is immediately delivered without delay to the jail indicated in the commitment order. So, yung number po is prosecutors handling the case must be reminded that the PNP Custodial Center in Camp Rame is only used as temporary lock-up facility po for persons under PNP custody. So, therefore po, under otherwise, specifically instructed by the Chief PNP po na yung mga high-risk detention prisoner po namin must be committed to the BJMP jail in Bicutan, Taguig City po. So there is an urgent need for us to revisit the budget of the PNP offices stations handling persons under custody po. The monthly operational and other expenses of said PNP police stations must contain a budget of PDL or our PUPC under custody to include funds for medical, physical examination, and for persons under custodial investigation. To execute the memorandum of agreement between the PNP and other government or private hospitals for the healthcare services of persons under custody, not to mention their need for a regular medical checkup. For the courts to fast-track and eliminate unnecessary delay in the resolution of cases. For our local and government units, the non-government organizations, and the DSWD po, siguro po, may we recommend kung to share expenses po to construct or for the improvement po of our custodial facilities, especially po yung mga CICL natin, and respectively, and to donate medical or hygiene kits to be used by persons under custody. Yun nga po, na-mention ko po na we don't have the MOE po for the allocation of the medical needs of our PUPC. We do not have enough budget po. So, for our best practices po, as shown po, the strict implementation of the PNP 2018-27 po, our daily subsistence allowance po are provided to the PUPCs, regular medical checkups po. So, meron naman po kami mga doctors and from the PNP General Hospital. And yung pumupuno na po dito is yung mga police officers namin from the different local na merong mga police stations po is they are closely in coordination po with the local health office po para at least po mas matugunan po yung mga medical needs po nila and makapag-conduct po ng regular check-up. So PUPCs are always apprised of their constitutional rights. Posting of PUPCs rights. So mapapansin nyo po, we have different posters kasi as we all know, hindi naman lahat is knowledgeable kung ano yung karapatan nila. So in our custodial facilities po, naka-indicate po doon yung different posters on 9745, yung mga contact numbers po, even yung poster na pinrovide sa amin ng CHR. And then meron rin po kami mga posters na nakalagay doon kung ano yung mga karapatan ng aming mga PUPCs. In Tagalog and local dialect po, meron po kaming mga distribute po nationwide. So last po is the regular conduct of human rights seminars and custodial officers orientation seminars. Next po. So those are some pictures po during the conduct of custodial officers orientation seminar. This seminar is one of our initiatives to ensure that our designated custodial officers are well-versed in their responsibility, obligations, and their accountability to PUPC. Also, a series of seminars on Nelson Mandela rules were conducted in partnership with the International Committee of the Red Cross. So we have been partners with ICRC for almost a decade na po, and we have done many initiatives po in partnership with them. We are also, right now, we are also in partnership with the United Nations Joint Program for the different programs and activities relating to the advocacy of human rights and awareness po. Next slide po. So shown are our initiatives on ensuring that our PUPCs are humanly taken care of. So ayan po, yan po yung mga sinasabi ko kanina, mga posters, and we are also conducting regular inspections po. So meron din pong mga nangyari na mga renovations in some of our custodial facilities, and yung iba pong police stations para alam naman po natin na nakakaburyong, yung boredom po is at least malesen natin. Yung ibang mga custodial facilities po natin ay, yung mga police station po natin ay nag-provide po ng mga television po para pampalipas oras din, and at the same time, aware sila kung ano nangyayari sa labas. Next slide, please. So for our ways forward po, we will develop a database system for real-time accounting of PUPCs in all PNP custodial facilities. So ito po is i-encode po. So kami nasa national headquarters, real-time accounting po yung mangyayari. Kung may in and out of PUPC po, pag may nagtanong sa amin, yun po yung at least talagang real time po. Alam namin kasi mahirap po yung monthly po kasi as in compliance din po with CHR po. We are submitting monthly accounting of our PUPC po. So ang hirap po mag-consolidate in our part para i-submit sa CHR. So ito po isa sa mga aming initiatives po para mapadali po yung sistema ng accounting po ng mga PUPCs namin nationwide. Propose for the increase of PUPC subsistence allowance kasi nga po at present, 50 pesos per day lang po. Detailed medical personnel to monitor the health status of all PUPCs and to man the consultation room. Provision of other medical equipment and over-the-counter medicines, and the improvement, renovation of custodial facilities. So our advocacy po, respect for human rights is a way of life in the PNP. That's all po. Thank you po.
Thank you, Major Consina. Now let's move to our last, but definitely not the least, speaker. He is a CPA lawyer and also holds doctoral degrees in Peace and Security Administration and in Criminology, and a master's degree in National Security Administration. He is the current Commissioner, Vice Chairperson, and Executive Officer of the National Police Commission, and holds the rank of Career Executive Service Officer 1 in Career Service. Let us give a round of applause to Attorney Alberto A. Bernardo.
Thank you. Okay. Good morning, ladies and gentlemen. I'll go straight to the context provided by the Honorable Associate Justice Maria Filomena Singh. It was very instructive and a revelation also. We also take into context the testimonies of Ate Lori and Kuya Sani. Now, we go to the specifics. It was found out that in the concept paper submitted by Justice Singh, that the arrest quota per day had placed enormous pressure to law enforcers, as a result of which they are compelled to make those arrests. And sometimes even minor offenses were being used as a leverage or to convert that to a compliance with quota. For example, in the hearing we had in the House of Representatives and in the Senate, in the Committee on Public Order and Dangerous Drugs, it revealed that a certain month they are supposed to conduct 10 arrests. But that is a thing of the past. When that hearing was held, we immediately summoned the PNP and imposed upon them. These are something that should not have been done at all to begin with. And we appreciate this submission of the concept notes by the organizer. Moving on. This quota was made from bad to worse because it has translated into an organizational culture. An irregularity to committed was being reinforced and being rewarded, in fact, because this has been the basis of performance and this has been the basis of promotion and advancement. And that is how we destroyed an organization. But this, again, is already in the past, and that is being currently addressed. Instead of what is being measured are something that has been a pernicious practice. and we are supposed to focus on the quality inputs. Whatever we place in the cell are supposed to be those people that are not supposed to be in open and democratic society. And so therefore, that would be the dissertation of this presentation, to show that what the efforts of the National Police Commission, which under the Constitution, we are supposed to deal with. And I agree, and I've been privileged to work with Undersecretary of the DOJ, and he has been a good example, and as a field of practitioners, he had shown how these things has been conducted day in, day out. And we will cite his accomplishment on that. And therefore, next slide, please. Under the law, we are supposed to measure the performance of the PNP, and this should be the basis of their professional growth. And so therefore, we intervene, and we are supposed to provide rating. There was an old saying that what you cannot measure, you cannot improve. What you cannot count does not count. And so therefore, it is necessary and indispensable for an organization such as the PNP of 228,000 strong are supposed to be a good machinery to address peace and order. And so therefore, as have been identified by Justice Singh in its concept paper, we are addressing that, and we are in the midstream, maybe next year. And now, we shall now go to the identified problematic area, the performance indicator. What are we supposed to get out of the performance, and what we are supposed to be rewarded are something that's supposed to be an exemplar performance indicator for a PNP. Next slide, please. We're glad that DC-20 is in our midst. For example, now in this current administration, what we are measuring is the evidence-based performance of the PNP. Unless and until you come up with those evidence that would substantiate anything that you will be submitting to the National Prosecution Service, that is a matter to contend with. Not one, not two, but all elements of the crime. And so therefore, we are now shifting from investigative to a paralegal organization. Unless and until you can enforce the law and what the law provides, and therefore all the elements are supposed to be there. Unless it is a prima facie evidence that has been submitted, then that is not a performance that will be considered. It will be taken against the police officer who have brought somebody before a prosecution office with incomplete documentation. Therefore, the new performance indicator, following the DOJ example, will be working closely together, is to ensure that all of these are looked into. And the close coordination and cooperation, it must start from the planning. In every bypass operation, there should be coordination with the PDEA, there should be a coordination with the National Prosecution Service to tighten the case build-up. And so therefore, the issuance is very clear. Next slide, please. I'm sorry. Next slide, please. And so therefore, these are the performance indicator. For us to rate, for us to promote any PNP officer, we would like to see to it that part of the performance indicator is at the stage of the planning. Because unless you plan the same, there is nothing at all that you could expect. This would be a disaster. And therefore, very clear, it is granularized in our issuance to the PNP. Kindly see to it that at the inception until the successful termination of the case. Ergo, you will not be given a full accomplishment to your undertaking unless and until you are with the DOJ until the successful termination of the case. If the case are bungled, you will be held with extreme prejudice. Why have you allowed those things to happen to begin with? And therefore, it specifically mentioned the proper collection and preservation of evidence. We know for a fact that drugs pushing has been elevated. For example, you could not see anymore that payments are given on the streets. Some of the payments are done in the internet. Through GCash, they are selling And through the padala system, you can now see drugs and synthetic items are now being trafficked without being seen on the streets. And therefore, the preservation order, for us to be able to secure those payments and those evidence, we are supposed to closely work together with the DOJ. And therefore, the training that we are supposed to provide is something that is substantive also. Meaning, therefore, whatever you are trying to measure for the PNP officer, you must institutionalize that in a manual of operation or PNP operating procedure. But it does not end there, that you must be able to ensure that those are found in the manual that you are trying to measure out of their performance are supposed to be part and parcel of the education and training. And so therefore, it does not end merely from the performance indicator. It must be institutionalized in a manual of operation, in the PNP operational procedure, in the training and education. It would start from the Directorate for Human Resource and Doctrine Development. It will be cascaded down to the National Police Training Institute for non-commissioned officer. It has to be inculturated in the discipline in the Philippine National Academy, where we try to hone the skills to become an officer. For those specialized training, it must not just be part of the program of instruction in the PNP training service. It has to be embedded. It has to be inculturated as a norm. And so therefore, it will start from the start and it goes up to the end. Unless and until we loop them together, it could not reinforce a norm, a better practice in the PNP. Moving on. Next slide, please. Another performance indicator that was suggested by the distinguished Justice Singh is to ensure that there is a certification of a prima facie case or evidence. And there is a reasonable certainty of conviction. It's not an expedition. Gone with the days of Ate Lori and Kuya Sani. That will not happen in the very near future. I hope it won't happen starting today, or shouldn't have happened to begin with. And therefore, the performance indicator, and these performance indicators are supposed to be found in the manual of operation of the various units of the PNP. And these are supposed to be found in the various program of instruction and in the training manual of all the units of the PNP. This is something that we are trying to institutionalize. Next slide, please. In the case of inquest, essential elements, and therefore we have granularized this in the instruction manual that we have been preparing. Maybe it will be rolled out next year. Very specific. Did the commander on the ground in handling the cluster of barangay, were you able to establish the essential elements of the crime to begin with? And you will not be promoted, and worse, you will be sanctioned if that has been done miserably. Okay, moving on. Having placed that in the PNP, next slide, please. Yeah. The Philippine National Commission will now conduct an audit to ensure that these things, we don't just issue policies and direction. These are supposed to be followed through. This has supposed to be realized at the end of the day. And therefore, an examination and audit of the performance, including the indicator. How about the activities? We have translated activities. Activities is, we have adopted the ISO 29001-2015, the Quality Management System. It's a process, the transformation of inputs to output. And therefore, policies and issuance is not at all an accomplishment to begin with as far as NAPOLCOM and PNP is concerned. Those policies, human resource, those capabilities, unless these are transformed into an output, the kind of arrest has been conducted in accordance with law. That is something that we are concerned about. It's not an input base, it's an output base that we're trying to audit. And so therefore, if the commander has is responsible for a process, he will be rated based on the output, the process output, not based on the process input. For example, you would see a commander would claim, oh, we have conducted 34 arrests. Would those arrests indicate a peace and order in the community? Would it impact on the drug affectation of a cluster of barangays? That is something that they are supposed to substantiate. The activities of conducting seminars and workshops, would those workshops be translated to a specific output based on performance indicator? What kind of output are we supposed to come up with? The outcome of a consultation, the outcome of barangay meeting, are there consensus, are there milestones that are supposed to have been identified? Are they be forthcoming? And therefore, in the conduct of audit, efficiency and effectiveness. For example, for a specific input, there are supposed to be a reasonable specific input, there's supposed to be specific output, and there's supposed to be timeline, and that is efficiency. How about effectiveness? The other one is doing things right, but you must be able to do the right thing to begin with. And therefore, effectiveness and efficiency is something that are supposed to be done across all police units in the country. Moving on. Now, there is also now an indicator that there's supposed to be an assessment of crime situation. Tapos na tayo dito. Next slide, please. Okay, inspection and assessment. Take note, we are supposed to measure the impact of the PNP in the community. We don't just see on the statistics. You will report the index crime is XXX. You will now show to us public safety index. But whether those really impact to the lives, to the daily lives, would the community feel safe at the end of the day? And therefore, the impact assessment is a necessary tool for us to be able to evaluate effectiveness of those police units. And what would those interventions and initiatives and outputs, not just activities, but outputs of those units impact on the welfare of the community and in the crime situation? Moving on. And therefore, there is a need for us to provide an operationalization of all of these things. Inasmuch as the National Police Commission is mandated to come up with a police manual. And therefore, we start with what we are supposed to get out of the PNP. A peace and order, a public safety. We have a specific, in terms of input reduction, we are supposed to determine the quality of arrest, and therefore the reasonable certainty of success of those that has been placed in detention. And for us to be able to operationalize all of these things, the entire spectrum of organization, administration, and operations. And therefore, in the PNP manual, you can find in the organization where in the organizations these things are supposed to be checked. Who are those that are supposed to check this performance indicator? Who are supposed to check on this, that these are placed in the manual of operation? 10 minutes. And then who are supposed to be responsible for the conduct of the training? You would now find out that in the National Police Training Institute, if you conduct X number of training, how many training outcomes are generated out of that training to begin with? Unless until you could ensure that that kind of training that you're providing are also being found in the operations manual, are also found in the performance evaluation, and output, in fact, and impact in the community. The kind of training that we are trying to do now is of no moment to begin with. And these are just rhetorical, and these are just empties. Moving on. Next slide. To conclude, again, we are supposed to ensure that these are part of the training. For example, we are veering to crime prevention because half of the battle is lost if the crime has been committed. The responsibility is to prevent that. And the crime of reporting that we are trying to get now is not log information. It must be diagnostic and predictive analytics. Can we benefit out of the socioeconomic profile, the demographic profile, the psychographic profile? That can we determine in this number of times, in this particular places, are there crime mapping to begin with? Can we prevent those crimes? We have been always telling the PNP, half of the battle is lost if the crime has been committed. Moving on. And therefore, to reinforce the good behavior and best practices, it is only then that promotions will be forthcoming. As have been observed by our our distinguished Chair of the Technical Working Group on Process and Capacity Building, the Honorable Justice Singh. We are supposed to review the promotion system, and these are currently being done. In brief, ladies and gentlemen, these are some of the initiatives that are currently being done. There are challenges, there are cultural changes that are being done. And we'd like to express our utmost appreciation for the organizer. These things, we would like to get support also from our stakeholders. And these things are something that we hope to do in the coming days. And in that, on behalf of the National Police Commission, maraming salamat at magandang.
Maraming salamat po, Attorney Bernardo. It is good to know that efforts are being made to solve the congestion problem. Pero nagpapakabait pa rin po ako kasi ayoko pong pumasok doon. So as we end this plenary session 3, I would like to leave this statement. When prosecutors and law enforcement unite their efforts, justice is inevitable. Thank you po, and I'll turn over to Attorney Laura.
I'd like to thank our distinguished panelists. Maraming salamat po for this morning's plenary session. Your honors, ladies and gentlemen, before you proceed to your breakout sessions, I have one announcement. The bidding for the art gallery, the art exhibit, will end by 3:30 p.m. 3:30 p.m. The winning bid will be contacted by Viber and will be instructed to proceed to the registration table to claim the artwork. Ms. Cel Bergado will receive your generous donation. Thank you po. Your snacks are already served in your respective breakout rooms. When you registered this morning, you were told which workshop po kayo and which breakout rooms. So please proceed now to your respective breakout rooms. We have a session here at the ballroom as well. Thank you. Magandang umaga po. We'll see you at 1 o'clock for the plenary session 4. See you at 1 o'clock at the plenary session. Thank you po.
A1C testing. AS1C. Check, hey, hey, testing. Check, hey, hey, 1, 2, testing. Check, hey, hey. Check, hey, testing. Check, hey, 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 hey. Good morning, ladies and gentlemen. There's a request for everyone to move forward, come up closer to the stage.
Okay, good morning, ladies and gentlemen. There's a request for us to move closer to the stage. Please occupy the tables nearer to the stage. Thank you. We will start once our speaker is already online because she will be joining us from the US via Zoom. Thank you.
Okay, good morning, ladies and gentlemen. Welcome to workshop number 10. Our topic is about how jailhouse lawyers and paralegals help in decongesting jails. Our main speaker for this workshop comes from the Jailhouse Lawyer Initiative, or the JLI. The JLI invests in what are called jailhouse lawyers, quote unquote. These are incarcerated individuals and those released after their incarceration who generally have no formal legal training, but they study the law to advocate for themselves and their peers. Most of the members of the JLI are serving life terms in prison, life terms, and are no longer working on their own cases. Now, because of their work as jailhouse lawyers, these advocates are often retaliated against and silenced by the very institutions they attempt to hold to account. Our speaker in today's forum is the founder of the Jailhouse Lawyer Initiative. She was once incarcerated in Florida. And while there, the librarian of the institution recommended that she train as a law clerk, hence her interest in the law. She is also involved as the central organizer for the state of Florida on Amendment Number 4. This is a campaign to restore the voting rights of over 1,500,000 Americans who are residents of Florida and who have felony convictions. Our speaker is the recipient of the 2019 Peace Builder of the Year Award, the 2020 Dr. Martin Luther King Jr.'s Legacy Award, and was a Soros Justice Fellow in 2018. Ladies and gentlemen, please welcome Ms. Jody Pope. Good morning, Jody.
Thank
Could you
you.
hear us?
Yes, I can. Can you hear me okay?
Yes, we can. Okay, please begin with your presentation.
Thank you. I wish that I could be with everyone, but I'm very excited to be with you all virtually to share with you a little bit about my own personal journey to personal liberation through the law and the work that we're doing at the Jailhouse Lawyers Initiative to also be able to answer a lot of the injustices that me and my communities are facing on the ground in the U.S. And so with that, if we can pull up the PowerPoint. I'm unable to see the presentation.
Okay, Jody, could you see the slide number 2?
So now I can see it.
Okay, thank you.
Thank you. So we can go to the next slide. Okay, so before we get into the presentation, I would like to just tell you a little bit about my own experience as a jailhouse lawyer and how it connects to my own current advocacy. So when I was 23 years old in 2007, I was sentenced to 8 years in the Florida Department of Corrections. And while I was incarcerated and came into the prison system, it was the first time in my life that I had ever been introduced to the law. For me, for myself, and for so many women, it was in the law library. Even though we had gone through the pretrial system to be convicted and incarcerated, no one had talked to us about the law. And I'll never forget the personal freedom and the legal identity that I had in reading the laws, and for the first time understanding what was even required of me, like how the law thought about me, what was my rights, you know, as a as a human being, as an individual that had these rights. And so for the very laws that were being used to persecute us and incarcerate us, once we were able to learn those laws and understand those laws became the very laws that we use to also liberate us. As well as incarceration was the first time that I ever had positive relationships with women. While I was a law clerk at the Lowell Department of Corrections, I was the law clerk to women who were on death row, women who were in closed confinement, in the infirmary, women who 1/5 of the female population, as well as I was the law clerk to youthful offenders. And I think this is very important because especially when we think about the youthful offenders in the United States, they have no access to any adults other than guards, other than their law clerk. And so for myself as a law clerk, in addition to supporting women with being able to use the laws, one of the greatest gifts that I had as a law clerk was actually teaching the women the law for themselves, understanding the law and being able to translate it into a language that we could understand, to even be able to begin to understand legally what we had gone through and what protections and what solutions may be for us. Even now in the United States, where we see a lot of laws that are changing around domestic violence, it's very interesting how some women didn't even know that they had gone through domestic violence until they learned and heard the laws that actually describe the things that we've gone through. Oftentimes, when we think about a jailhouse lawyer or incarcerated legal worker, we would imagine that this individual is just doing post-conviction actions. But as a law clerk, I actually worked on family law, civil law, immigration, constitutional law, as well as I helped women use the law to be able to navigate issues that we were facing within the institution. And so when I returned home from incarceration, I had a legal identity as a lawyer. While I was incarcerated, I unlearned everything that I had learned about myself as a Black woman in the South in the United States. And I was armed with the law. I loved the law. I had this legal identity. I wanted to come home. I wanted to practice the law. I came home with the plan. And to this day, I've still not yet been able to get a law degree. But it was so many times when we think about recidivism, here I was in college with my children, working towards my degree, working, and there were so many times that I'd rather had been back in prison because I actually had a legal identity, a purpose, and a means to be able to utilize the advocacy as well as the legal knowledge that I had. And so there were so many times that I could have recidivated and gone back to prison, but it was my dream of becoming and being a lawyer that not only kept me alive, but also gave me the opportunity to be able to create the Jailhouse Lawyers Initiative. And another thing that I will name, in the United States, we have what are called collateral consequences, meaning that there's all these laws and policies that once a formerly incarcerated individual is returned back into community, that there are all these legal barriers against you. And so I have what's considered a violent offenses. And so when I came home, I couldn't live in most complexes. And I have children. They were also stigmatized and criminalized as well. And so a knowledge of the law also helped me to navigate housing. It helped me to navigate collateral consequences. It helped me to navigate as well as to identify legal issues and harm that was happening in school settings and work settings and employment settings, as well as my knowledge of the law was what helped me to navigate business entrepreneurship and advocacy. And because I wasn't able to use the law as a lawyer once I returned home, I was able to start the first participatory defense hub inside of the state of Florida. And so that was an outlet for me to be able to use the law. And then in 2017, I was introduced to community peace building. And so the practice of restorative justice, values, needs, social emotional learning, communication, self-esteem, while these practices were being taught to youth as an adult who was once a youth and grew up, I couldn't understand why I had never been introduced to any of these practices before. No one had ever talked to me about needs. No one had ever really talked to me. I could tell you the definition of values, but I couldn't tell you what my personal values were or how my brain worked and how my emotions were actually connected to what I was thinking and what I was feeling. And so peace practices, along with legal empowerment, have become some of the most powerful tools that I've been able to use in my own personal efforts as a mother and a formerly incarcerated jailhouse lawyer. And in 2018, when I was introduced to legal empowerment, that also introduced me to human rights. At this point, I had been home for almost 4 years, had never heard about human rights. But when I was introduced to legal empowerment, the SDG 16 became my love language. It was the first time that I heard about data and was introduced to participatory action research. And so I really hope that as I go through the presentation today, you will not only be able to see examples of what legal empowerment and community peace building can look like and how they can be tools to break cycles of incarceration or to empower incarcerated communities. I hope we will all see an example of what it looks like when incarcerated and formerly incarcerated individuals like myself have the tools to be able to show up and participate inside of society, that we can have more versions of legal empowerment tools that reach back into community. And we can go to the next slide. So if I had been in the Philippines with you all, I would probably know most of your names and would have connected and we would feel like we are in community. And so since I am not there, before we jump in, I would like to ground us in 2 points. And so one of those first points is that the jailhouse lawyering, which is a term that not all incarcerated legal workers go by, but it is a term that we've adopted at JLI and that I personally use to describe my own experience. But jailhouse lawyering is not just something that was made up. In the United States, your constitutional, incarcerated people have a constitutional right to have access to the courts. And so these on the screen, you can see the Johnson versus Avery in 1969 was when the US Constitution first established that prisons in the US could not bar incarcerated persons from helping each other file cases unless they provided an alternative help. And when in Bounds versus Smith in 1977 was when the Supreme Court explicitly articulated that incarcerated individuals should have a right to meaningful access to the courts. So inside of the United States, the way prisons meet this access to the court is that they either have law libraries with incarcerated individuals who work inside of those law libraries, or the prison can contract outside help of legal offices who would provide that help from the outside. And so law clerks and jailhouse lawyers can look a little different. You have the law clerk who it is their assigned job, like it was my assigned job to work in the law library. And then you do have individuals who are just paralegals, individuals who are known for using the law. And oftentimes this could be because the institution, because of retaliation. If you know too much of the law in some places, that could be a barrier of having you within the law library, or because there could be limited spaces. So not all jailhouse lawyers is their title and official role to work in the law library, but sometimes jailhouse lawyers exist in prisons where there is no official law library, or there may not be a job assignment for them. But these are the two primary cases that establish law libraries and law clerks, which we refer to as jailhouse lawyers inside of the United States. And we can go to the next slide. So as you already heard, in addition to legal empowerment, peace building is a huge part of my own personal practice and our practice at the Jailhouse Lawyers Initiative. And so the socio-ecological model was something that I was introduced inside of the peace building world that really is in the behavioral health space, that shows the interrelationship between personal and environmental factors. But the way that we use this in the legal empowerment sense is to recognize that we're all on a spectrum, and that each individual is at all times experiencing the world through these multiple ripple effects. And so each individual has their own knowledge, own attitudes and skills, right outside of that ripple effect is typically when we talk about, for some people, my community is explicitly my family, my friends, my social networks, and the people that I'm connected to. For some of us, we have an even larger ring of having a relationship with the communities and the organizations and institutions that actually exist outside of our neighborhoods. And then even beyond that, this relationship with higher organizations, state, national, local laws, and even beyond in a global lens. And so one of the things we recognize at the Jailhouse Lawyers Initiative is that for some people, I'm only inside of my individual bubble, and I'm only thinking about using the law for myself, or I only have a lens that is around myself. For some people, when we're thinking about community, that lens only goes between me and my immediate family or my incarcerated community. And oftentimes for the law students that we work with, they are able to travel in multiple ripple effects or lens. And so it is a gift for us to have multiple lens. And so we invite you, as you're listening to the presentation, to recognize that for some of this will connect with you as an individual. Some of it will connect with you at your experience from a community and a public policy lens. And so, but for a lot of incarcerated individuals, our lens of how we are thinking about and responding to and processing, shaping and thinking about the law could be also very individual and interpersonal and not be in a systemic or a larger community lens. And so we're just recognizing that we do have multiple lens, and it is a gift because the law is fluid. And so our lens has to be fluid when we're thinking about people as well. And we can go to the next slide. Okay, so finally, we're going to jump into the presentation of who is JLI and how are we approaching legal empowerment inside the U.S. through Jailhouse Lawyers. And we'll have a short video that we're going to show really quick, and then we'll get back into the presentation.
Jody, are you there?
Yes, I don't see the presentation.
Okay. What slide would you want to project on screen?
The JLI mission. We can go to the next slide.
Okay, next slide, JLI's mission.
Yes. So the mission of the Jailhouse Lawyers Initiative is that JLI advocates for the legal empowerment of current and former jailhouse lawyers, a process that we believe is central to ending the cycle of incarceration and enabling communities to obtain freedom from the inside out. And it's very interesting because when I started the Jailhouse Lawyers Initiative, I wasn't thinking about jailhouse lawyers as this poor, community of people that needed all this help, but was recognizing when I came home from incarceration and was seeing, it was the first time I was even seeing advocacy on the ground or hearing about abolition or seeing formerly incarcerated movements. And so seeing all of this movement happening on the outside and then having this awareness of the experts who were doing all this amazing, phenomenal work that was oftentimes invisible because we're pro se litigants. It was very important that jailhouse lawyers we created something that connected incarcerated individuals, mainly a lot of people who are serving life, with the movement that were happening on the outside. So when we think about jailhouse lawyers at the Jailhouse Lawyers Initiative, it's just not a core group of people on the inside, but it's actually those who are closest to community, is those who are closest to the solutions, is individuals that we think are missing from our legal ecosystem, and it's individuals who are invisible but very present. And we can go to the next slide. We have 4 goals at the Jailhouse Lawyers Initiative to achieve our mission. And so the first is to build and support a national network of former and current jailhouse lawyers. Our numbers now are over 700 incarcerated jailhouse lawyers on the inside. Our outside memberships looks like law students, lawyers, and formerly incarcerated jailhouse lawyers. We also work to co-develop and teach legal education and empowerment trainings for incarcerated individuals. We raise the visibility of jailhouse lawyers as essential members of the legal ecosystem in the U.S., as well as we work to develop pathways for jailhouse lawyers to return our legal skills and knowledge back to our communities during and after incarceration. And it's so important to think about the during, and we'll see it throughout the presentation, but individuals have the ability to create ripple effects of legal empowerment from inside of prisons. And it is because of individuals who are serving life and teaching and modeling and practicing the law on the inside that a lot of individuals like myself can come home with these practices and these skills and these motivations to be able to bring these laws back into our communities. And we can go to the next slide. Our core values at the Jailhouse Lawyers Initiative, I'm going to break these down a little bit further, but we truly are rooted in legal empowerment, that people have to know, use, and shape the law, participatory action research, and the way we think about PAR at the Jailhouse Lawyers Initiative is not just a research tool, but it's an ethics of care, of how we think about how do we build relationship between the jailhouse lawyer and lawyers? How do we restore relationships between the institutions that we're working between? How can we use PAR as an ethics to be able to think about who should also be at the table that might be uncomfortable to have conversations with, or who we've been generationally isolated and kept separated from? But also we think about PAR as a tool to really develop these relationships and a working relationship. Sometimes people will ask me, do I think that jailhouse lawyering is a way of replacing lawyers, or community paralegals is a way of replacing lawyers? And absolutely not. We believe that legal empowerment is an opportunity for us as community members to work with lawyers and to become lawyers and to fill in all these gaps that we see inside of the justice system, as well as we value community peace building, which is recognizing that conflict is inevitable. And so we have to have conflict resolution skills, especially within the law. restorative and transformative practices, trauma-informed care, and social emotional learning. And oftentimes we see this again being taught is prioritized to youth. And we see it in the schools, and we're seeing it more inside of like the institutional spaces of having this training. And it was because of my work in an organization that I was able to have access to it. And so we truly value making sure that incarcerated leaders and experts as well have access to conflict resolution and peace practices. And we can go to the next slide. So to understand a little bit about legal empowerment, I was introduced to legal empowerment in 2018. And in the United States, we really think about the response to criminal injustice or injustices in the criminal justice system as reforms or abolishing these systems altogether. And I have to tell you, when I first came home and was introduced to the this notion of abolishing prisons, I was not at all I wasn't brought into that. And it was a time I could not imagine what a world could look like without jails or without police or without prisons. And so it wasn't until I was introduced into legal empowerment that even myself as a formerly incarcerated community member could really understand how incarceration can be a cycle and what it means to actually disrupt the cycle of incarceration. And so legal empowerment at its heart of the justice system includes people, and it's also a methodology of recognizing that people have to know the law in order to use the law to shape and transform the law. And that was very important for me because even when I worked on the campaign to restore voting rights, that was post my conviction. And I actually only worked on that campaign because I thought it would help to get me into law school. And I was trying to build community. To be honest, I did not care about voting. I was not thinking about voting. But while working on the campaign, I learned so many things that I did not know about democracy, about my community. I did not even recognize that we voted for city commissioners. I did not understand what the local elected officials, how they actually connected to my community. And a lot of times when we stereotype and we judge communities as poor or marginalized, we fail to also remember that aside from all of that, we're isolated communities. You know, going back to that model, the social ecological model of recognizing that we all are part of this big community, but oftentimes how people are associating and connecting with community is very far removed. And so it's so important that a lot of times, especially when people return home from incarceration, we're thrust into shaping the law. Join this advocacy group. Go tell your story. We have to change legislation. We have to change policy, not recognizing that most people haven't even had an opportunity to know and use the law. And when we approach people in a harmful way, it can actually create people to just say, I'm not going to even participate inside of the law. And we can go to the next slide.
Jody, just as a reminder for you and for our audience here, you have 25 minutes left in your presentation. Thank you.
Thank you. And so legal empowerment is anchored in the basic principles of human rights. And so some models of legal empowerment is community paralegal programs, know your rights training, community-driven litigation, mediation. And one of the things I love about legal empowerment is that it's not a one-size-fits-all, but it's a framework that can have multiple practices built into it. And we can go to the next slide. A way that we use the Jailhouse Lawyers Initiative is JLI was created to be what we call a three-strand cord. So it is a relationship between the community, which we consider to be jailhouse lawyers, law clerks, formerly incarcerated jailhouse lawyers, especially law students. We depend a lot on law students inside of our work in the institution of the law school and the prison law library. So JLI currently is housed at NYU School of Law, and it is meant to be in the very institution. And so wherever there's a prison inside the United States, the model is set up is that the prison will be connected with law schools where law students are able to have relationships. They go in and they teach the curriculum. They help co-develop the curriculum, and they build these relationships that, you know, also works as a double-edged sword for the law student, the future lawyer as well. And so we see this transformation that happens just in the relationship building that we do of braiding jailhouse lawyers, and law students together. We can go to the next slide. Correspondence, you saw in the video how we look at correspondence. Some of the other ways that we've been able to see this ethics of care show up inside the jailhouse lawyering is that law students are now also monitoring risk and security when it comes to institutional policies and practices around how incarcerated individuals get the mail. We also have inside advisors, mainly those who are, you know, serving life on the inside, but these individuals are directly working with JLI for us to have an understanding of how we can create better legal resources. What is the culture of the community on the inside and the ways that people are thinking about the law? So we're not just creating legal information and sending it on the inside, but actually creating legal information, accompanied with advocacy tools so that people are able to use these laws in the long term as well for their immediate needs or collective. Because of this work and this introduction of lawyers and law students to incarcerated legal workers, law students are now doing days of actions where they get together throughout their quarters and they respond to the needs of incarcerated individuals. Law students on their own also created pen pal programs where they start to recognize jailhouse lawyers as peers of learning the law, and they're having deeper conversations. And we're also creating a digital public archive where we're able to share the advocacy of incarcerated individuals with elected officials, with leaders, with other legal actors within the legal ecosystem. And we can go to the next slide. We can go to the next slide. This is another example of how we approach this collaboration between lawyers, law students, and incarcerated individuals. In addition, because we are a national organization, so each state is very different and unique in its own, but we also create these national modules and toolkits where law students, based on what we're learning from incarcerated legal workers, they will actually do the desk research, they will interview lawyers, judges, formerly incarcerated jailhouse lawyers, incarcerated individuals, and based off their studies of the law, their research of the law, and the interviews that they're having with these various actors, we draft these national modules so people are learning the law, learning these tips, culture, tools of the law, and then we actually have a process that it feeds back from the inside and then to us on the outside. And to date, we have about 9 national modules that are being used inside and outside of prisons. And we can go to the next slide. Feminist circles, just wanted to talk about this. Out of our 700 plus membership, about 93% of them are men. And we started to recognize over the years that women were not writing to us, not using the law or engaging with the law in the same way that men were. And so because of this participatory action research ethics that we have, we started a feminist power project where we started having feminist circles, where we just started having conversations with women versus just trying to rev up the women in our membership. We started creating spaces online where we would have these conversations with formerly incarcerated women. And now, a year into it, we understand gender injustice in the language that women are speaking, in the ways that women are talking, which are very different from men. So it also required us to shape the way that we were interacting with incarcerated individuals. And so it's another way that we're also leveraging community to support incarcerated individuals on the inside. And we can go to the next slide. We can go to the next slide. So community paralegals. Community paralegals are different from your conventional paralegals that we see in the US. I abroad learned about community paralegals, and their primary role is not to assist lawyers, but rather to work directly with the communities that they serve. And so they're trained in basic law and in skills like mediation, organizing, education, and advocacy. And so jailhouse lawyers in the United States are community paralegals. Oftentimes when we come home from prison, to be able to get a law degree and actually enter into the legal field to be able to talk about the law or utilize the law in community, it removes us further and further away from our communities. And so the community paralegal model is something that we're embracing inside the United States. To think about why people shouldn't have to have a law degree to be able to talk about the law and use the law, and what does it look like for organizers, especially us who are trained in the law on the inside and are practicing the law. We have jailhouse lawyers come home from prison after using the law for 30 years, 20 years on the inside, have immense amount of legal knowledge and are unable to bring those skills back into community. So bringing this model of community paralegals into the United States is something that we're really looking forward to as another way for us to be able to, for our legal skills and knowledge to live with us inside of our own communities. And we can go to the next slide. We can go to the next slide. So the impact of jailhouse lawyers, in addition to Johnson versus Avery, which established, it was a jailhouse lawyer, it was an individual incarcerated legal worker who established the law that allowed us to be able to have access to law libraries and access to the courts. But these are actually two of my brothers. These are two formerly incarcerated jailhouse lawyers. Calvin Duncan is responsible for ending the non-unanimous jury convictions inside of the United States after spending close to 30 years inside. He just received his law degree. He lives in New Orleans, and he is now working with the Department of Corrections inside of the state of Louisiana to revolutionize the way law clerks and jailhouse lawyers are learning and using the law inside of the U.S. And then Derek Hamilton, who is now home, established that actual innocence as a freestanding claim inside of New York. And he is one of the most active former jailhouse lawyers across the country now, using his legal skills to teach the law inside of prisons. He's also creating community law libraries inside of the communities that he's from, and being able to organize resources and law students to be able to help individuals on the inside respond to their legal needs. And we can go to the next slide. And so when thinking about how can we decongest and disengage, and how we approach legal empowerment as a tool of abolition inside of the U.S., and we can go to the next slide. The way we see it in the U.S. Is that incarceration is this cycle. Inside of communities, individuals face poverty, substance abuse, all types of issues that we know are the pathways that lead people inside of, lead people into incarceration. And then once you, your needs are not met, and then violence happens, harms happen, and a person goes into the criminal justice system, after arrest, you go through the pretrial, trial, which if you don't have bail, you spend that time in jail, into the prison system, which we call the post-conviction phase. From the post-conviction phase, you go into reentry, which reenters you often back times right back into the same situation that you were in before, which initiates recidivism, and you get stuck in the loop over and over and over and over again. And the way that we're disrupting, disengaging, and disempowering this cycle inside the U.S. through legal empowerment is, first, I have to give props to the participatory defense movement, where family members are working with public defenders at the pretrial phase to be able to get the best possible outcome for the loved one. And because people still go into the prison system, that is where the Jailhouse Lawyers Initiative really takes effect. And so because jailhouse lawyers, oftentimes those who are serving life, we're greeting people from the time that they come into the prison. Reentry is beginning from the time a person comes into the prison, and utilizing this opportunity of learning the law, understanding yourself, the peace skills, being able, first of all, law clerks are used, jailhouse lawyers are gaining these conflict resolution skills and peace skills first for themselves. Because we are, I think one of the most powerful positions of the jailhouse lawyer is that we're also a peer. to our peers inside of the incarcerated community. And so through the modeling and the teaching of legal empowerment and community peace building, what we're seeing is that people are returning home with the legal understanding of not all of the laws and don't have a legal degree, but people understand what the law is, that they have a right to use the law, that the law should protect them, and that they have a healthy understanding of who is in the legal ecosystem and how to engage with lawyers, civil society, legal aid in a way that we're not isolated and not getting our needs met. And so through jailhouse lawyering, participatory defense, we're seeing community paralegals come from outside of prisons, returning back into our communities in a way that we can think about civil law, environmental law, reproductive justice, community justice, transformative justice, which are conversations that was often happening in government. These conversations are happening in legislation, they're happening in institutions and organizations, but the true opportunity to be able to disrupt, to decongest and disengage is when these practices and these tools come into community. And oftentimes that doesn't look like the policy makers and holders coming into community, but the jailhouse lawyers are in position, the community paralegal is in position to be teaching and introducing the law in a way that we can see participatory governance inside of our communities. And we can go to the next slide. So some of the barriers that we see with jailhouse lawyering is the lack of recognition for their successful interventions. Again, individuals have been utilizing the law, and that's why I love PAR. People know the law. We might have different languages that we use, but individuals have experiences with the law. People know what's best for them and solutions are best for them. But oftentimes, because we don't have the degrees, because we don't have the experience, because we don't have the relationships, we're not seen as being the solutions for our families and for ourselves and for our communities. Also, prisons retaliate. We even see this with lawyers as well, that when people have legal knowledge, it can be seen as a threat. And so we're hoping that legal empowerment could be a way to disarm that people having legal knowledge is a threat. Legal knowledge, we believe at JLI, is a pathway to access, not the only pathway, but is one of the pathways to access justice. The lack of resources and training. Most incarcerated jailhouse lawyers are self-taught, and they're learning through trial and error. And so it's one of the reasons why we truly believe that relationship is just as important as being able to share the law, but people have to have that ongoing continuing education of what's happening and how policies are changing on the outside, and then the inability to bring those skills back home after release. And then we can go to the next slide. And then the unauthorized practice of law, which is very interesting. We have the constitutional right to be able to use the law while we're incarcerated, but once you come home, you can, face prison, jail time, or fines and fees, which we've seen for some jailhouse lawyers who have come home and tried to start their own paralegal practices. And so that is an area that we are currently hoping to take up to the United Nations and to, continue to push that UPL is a violation of human rights, but we do recognize that it is a barrier. As individuals are using the law and bringing it back, UPL can then become a strategy to be able to use legal knowledge against individuals. And then we can go to the next slide. All right, so I hope I rushed through some of those slides. I hope that this presentation was an opportunity to really show how jailhouse lawyers can really help close the gap, especially when we think about a lot of the advocacy efforts that I see inside the United States. It's not that they're not good efforts, but oftentimes these efforts and the laws, the hard work that is happening is so far removed from the people who are actually going to benefit from it the most, or the people who we're talking about. And so incarceration, I've noticed, it's hard to get a person to want to think about democracy or shaping the law or changing the law when I'm trying to survive, when I'm trying to figure out what I'm going to eat, when I'm battling addiction, when I'm the primary caretaker of my family. And so even for myself, it was in prison that I actually had a chance to stop and to unlearn and to think. And until we don't have those systems in place where that has to be how a person learns the law, we are leveraging our position inside of the prison institutions as well as our position inside of the law schools to be able to make visible that we have something to offer and that we are here to help reimagine how we can continue to expand access to peace and justice for all. And if there's any questions about jailhouse lawyering, how we're utilizing any of the values or how this work looks in practice, I'm really happy to answer any questions.
Thank you very much, Jody. We will reserve the question and answer portion after the reaction of our speaker, our next speaker. So again, thank you very much, Jody, for that very informative presentation on how incarcerated persons could empower themselves and others to help ease the difficulties of persons deprived of liberty and decongest jails. Just as an interesting tidbit related to your efforts to help restore voting rights of incarcerated formerly incarcerated citizens in Florida. In the Philippines, during the last elections, almost 30,000 inmates of the Bureau of Jail Management and Penology were able to cast their votes. 30,000. Okay. Our reactor to the presentation of Ms. Jody Polk comes from the Humanitarian Legal Assistance Foundation, the HLAF. This organization focuses on the protection of PDLs, especially those most vulnerable, like children, the elderly, women, the sick, and the differently abled. HLAF's main purpose is its main program is its jail decongestion program. HLAF seeks to empower PDLs through the provision of basic legal knowledge. And while it continues to go through jails and court records for inmates eligible to be released and then work for their release, HLAF also works to change the punitive attitudes of the community and key jail officers. By doing this, HLAF believes that officials concerned in the community will be more sensitive to prevent arbitrary, unlawful, and unnecessary deprivation of liberty. Ladies and gentlemen, let us welcome the Jail Decongestion Program Manager of the Humanitarian Legal Assistance Foundation, Attorney Aubrey Ruby Sadural. Aubrey.
So, magandang umaga po sa atin lahat. Good morning to our esteemed moderator, Justice Carl Miranda, to our esteemed speaker, Ms. Jody, and for the participants here today po. So, first, let me ask a question. Ready na po ba kayong sumayaw ng tinikling at pandango sa ilaw? Because we are situated here in the ballroom, no? So binigay sa atin itong room na to. But I will, let me divide my reaction to the presentation of Ms. Jody into two parts po, no? First is my observation or thoughts about her sharings, how can we elaborate or how can we replicate the good practices here in the Philippines. And second part po is the jailhouse lawyers concept, but in the context of in our country, in the Philippines po. No? So first, for the first part, I do agree that sometimes, most oftentimes po, no, that incarcerated persons will feel and experience that they are nothing po, no? But because po, no, activities that are being provided inside the jails, no, the jail officers, the legal service providers, po, no, they build piece by piece their worth. And sometimes they so much more po, no, yung worth nila mas tumataas pa kaysa yung nasa labas. No? Second po dun sa part 1, by part 1 is a question in relation to slide, Ms. Jody, slide 17 and slide 23 in relation in the UPL or an unlawful practice of law issue. Does the term, or because the term of jailhouse lawyers, does this hinder does this hinder them in performing or assisting others outside the jail because it is viewed that what they do is practice of law, which is prohibited, or is it because they do practice of law, but it can be coined as assisting or doing paralegal works and in collaboration with American lawyers? Okay. Next, for third question, for slide 15, the feminist circle. Aside from dialogue, doing dialogues with the female incarcerated person, women, incarcerated women, can you share additional information or activities that caters specifically for incarcerated women? And does these activities also extend to incarcerated person who identify themselves as women or female? So yun po yung for my first part, which our speaker can elaborate later po in our question and answer portion. Okay. For my second part po, so again, jailhouse lawyers, but in the context, in our context po, no? So Philippines empowerment of PDLs through basic legal knowledge. Next po. Okay. So, in our country, we use paralegal coordinators and paralegal aides. It's a context wherein persons deprived of liberty or PDLs are trained and capacitated to assist and monitor the key status of their co-PDLs, thus empowering the PDLs to play a role, no, to play a supporting role. Again, I emphasize, to play a supporting role, not only para collaboration among the justice, no, play a supporting role, assist their lawyers, assist the jail paralegal officers in the jail. So play a supporting role in advocating the well-beings and the rights of their co-PDLs inside the jail. Next po. Ay, balik po sandali. Okay, para iyan ko lang po yung picture. Sorry. Can you turn? So you can see po, our paralegal coordinators, the one standing po, they facilitate po and conduct trainings inside the jail where they share what they have learned during the trainings po, no? But it is, their trainings are under the supervision and still guidance of the jail paralegal officers po, no? So instead of the jail paralegal officers doing the training, so the jail, the paralegal coordinators are the one po, no, training and orienting the newly committed PDLs po inside the jail. Next po. Okay. Capacitating and mentoring paralegal coordinators po, no? So these PLTs po are provided with the concept of paralegal trainings or PLTs po, no? So we do equip them with the necessary skills, basic law and legal procedures, communication skills, and advocacy skills. As you can see po, there's a module where paralegal ethics and values. Why? Because when they do become paralegal coordinators po, no, they should avoid the money-making business po, no? Diba? So, they not only assist, tutulungan lang kita, I will assist you, but you have to pay me. So, we show them that being a paralegal coordinator is a responsibility din po inside the jail po, no? So, as you can see po, for the photos, these paralegal PLTs are conducted by the law students, law interns, sometimes the legal management students, no? So these law interns, volunteers, they play a crucial role po, no? Not, hindi lang sila, they do not only follow up the key status of these PDLs, but also they, how do they impart the laws that the PDLs will be able to understand and replicate to their co-PDLs po, no? So aside from the legal jargon, kung English man yan, how do they explain po, no, in Filipino or Tagalog po itong laws natin? And then, I think all of us can relate po, no? During the pandemic, no, all of us have to adapt po, no? So these PLTs po, until today naman po, minsan ginagawa namin po, no, they are conducting online po, no? Minsan mas okay pa nga po kasi mas malaki yung reach po nung ating PLT. Okay po. Next po. Okay. So, what are the roles of being a paralegal coordinator? So let me share po through good stories po, no, what we experience po, no. First po yung sa second picture, first is the community building po, no. Through paralegal aids, they foster a sense of community and a shared responsibility. So what do we mean by shared responsibility? Not only na they do monitor their cases, but the other cases of their co-PDLs. Ms. Jordan, if you just indulge me po, no. One of the PDLs shared po in Filipino na pagkatapos na kami ay nagtitraining, sa gabi, pag gabi na po, pag pumapasok na po sila dun sa kanilang dorm, ang sabi po nila, pinupuntahan na ako ng mga kasama kong mga PDLs na hindi nakasama dun sa training at tinatanong na kung ano ba yung natutunan mo, may apply ko ba yon sa kaso ko. No? So at isa din po doon dahil sa PLT, kaya may sense of community. Kasi na shinare po niya na dati, di po ba, kapag papasok ko doon sa community na yon, minsan mag-isa ka. Po, no? Hindi mo naman sila lahat friends, pero dahil sa paralegal, nagkakaroon siya, nagigain siya ng friends. Po, no? Kasi may nagtatanong na din sa kanya. No? Medyo may leverage na siya for fostering friendship din po.
Attorney Sadural,
Yes po.
for Jody's benefit, could we have a short translation of what you just said?
Yes po. So one of the PDL shared that because of the because he as a paralegal coordinator, he gained some friends. Because some of the PDLs after the training, they approach him to question or to ask about their cases. So in a way, they parang beneficial for both of them po. Okay. For training and capacitation, would you believe that this affidavit was drafted by our paralegal coordinator? No? So, our paralegal coordinator drafted this affidavit of denial, and the PDL was released because of this paper. No? Because there was an issue, he already served his sentence, but another case was filed again with the same name. But he said, that's impossible because, syempre, I'm incarcerated, so how can I commit that offense? No? So, etong paper na lang po ang kulang para mag-release siya. So, hindi pa magawa. So, at least, because of the assistance po, no, for the drafting, the PDL was released po. Okay. Okay. Advocacy for rights po, no? If you browse the presentation of Ms. Jody and their website, Jailhouse lawyers acts as a, if I'm correct po, as a bridge. I think it's bridge builders po, no? For in the Philippines, they are paralegal coordinators. Yes po. Our paralegal coordinators acts and advocates po, no? Acts and advocates for the rights and well-beings of their co-PDLs, raising awareness or raising issues po, no? An example of this, during the TFKK or the Task Force Katarungan at Kalayaan, is this parang concept po niya, same with the localized justice sector po, no? Where the different justice sectors, we have the judge, the PAO, the prosecutor, the probation officer, the PNPB, GMP. as you can see, our paralegal coordinators po, no, they do not only observe how the justice system works, but they participate, they proactively engage po in the conversation, in the dialogue. No? They are the one who raise the issues, not only their issues, but the issues arising, common issues found inside their jails po. And then our justice sectors, nalalaman po nila kagad po, no? Mabilis. That's what we call express dialogue po, na re-resolve. Sometimes it is resolved in here in the dialogue po. And another thing is the PDL, sometimes when we do visit the jails, sometimes they share that parang walang ginagawa ang aming walang ginagawa ang aming judge. In translation, Ms. Jody, sometimes as if the judge, our lawyers are doing nothing. But because of the dialogue, they realize na gumagalaw naman po, no? So, so medyo dun din po sila nakakatulong. Next po. Okay. Last naman. Okay. So, if I may, yes po, if I may end po, no, in the Philippines, empowerment of PDLs through basic legal knowledge, we are starting to recognize the potential of PDLs po, no, to positively contribute po in our justice system po, no. And then this approach po, itong empowering our PDLs, reflects a shift to a more participatory and rehabilitative mode of including PDLs and paralegal coordinators in the Philippine criminal justice system. Kasi bakit nga naman po tayo nandito ngayon, no? Kahit wala sila, pero at the core of what we will do, of what we do and what we will do po, no, sila naman din po yung magbe-benefit. So, thank you po.
Thank you very much, Attorney Aubrey. Now we go to the question and answer portion of our activity. Attorney Aubrey had several questions for Ms. Jody. Would you want to ask those questions? And let's ask for quick answers to the questions that you will be asking. Now, for those who would like to ask questions, you may either approach the microphone and ask your question, or write your questions on a piece of paper, which we will be reading up here. We just have a few minutes for this purpose. So, Attorney Aubrey, could you please repeat your questions for Jody to answer?
Yes po. Hello, Miss Jody. I'm Aubrey. I think is it good evening there or good morning?
Good evening here.
Good evening. So magandang gabi po, Miss Jody. So my first question, I'll just repeat my first question po, no. This relates to slide 17 and 25 of your presentation. I think they are interrelated. Does the term, or because the term jailhouse lawyer hinders them po, no, in performing or assisting others because it is viewed that what they do is practice of law, or because what they do is practice of law, but can it be termed as assisting or doing paralegal works in collaboration with with lawyers? Yun po yung first.
And so the name jailhouse lawyer has its controversy that starts with our courts that look at us as frivolous filers inside of the courts. And so the most stigma that would come with a jailhouse lawyer is that that individual doesn't have knowledge of the law. From the research that we've done, we've actually seen that UPL is actually used against more lawyers than is actually used against community members using the law. And what's also very interesting in the US is that you don't have to have a lawyer to do a lot of like civil, to help someone with civil injustice issues, but it's once you get into the criminal justice system that we really start seeing this barrier between really being able to utilize the law. And that is something that we're bringing to the UN, you know, of like, what is this line between teaching the law and knowing the law versus actually practicing the law. And one of the things that we're hoping to see is that, especially formerly incarcerated jailhouse lawyers, how can we be viewed as human rights defenders, and what would that look like? But we do, the jailhouse lawyers term on the outside has more fear of the knowledge that we have, but there is more stigma on the term of jailhouse lawyer from the courts, from the incarcerated side, of not knowing the law. I hope that answers your question.
And what's the next question?
Thank
Aubrey?
you for that answer, Ms. Judy. For the last question, slide 15, the feminist circle. You mentioned an activity or a dialogue between jailhouse lawyers and incarcerated women. So aside from dialogue, can you share other activities that involve or that specifically caters to incarcerated women? And does this activity extends to incarcerated person who identifies themselves as women or female?
Yes, it does extend to anyone who identifies as women and female, and we do have some women who are in men's prison who are part of the feminist circle. In addition to the dialogues that are happening inside, so law clerks are also having the same dialogues that we're having with formerly incarcerated women. They're also having these dialogues with the incarcerated women community. And then we collectively share notes every month. And so we also, from this process, have come up with Skillshare, where women have recognized that in addition to learning the law, they have these other skills in practice, and that healing is a part of it. And so we're learning breathing, and we're practicing physical touch and yoga, and women are teaching their own ancestral in this space, which is also very interesting. Women choose to bring in ancestral knowledge and practice and culture into the space. And we also do a lot of, we don't just do writing, but we do painting. We do it through arts, we do it through dance, we do it through music, and we're doing it through creative writing as well.
Thank you very much, Jody. Now, before I read the questions sent over, would anyone like to ask a question? Please. Yes. What is the question?
I am asking the question on behalf of my seatmate here. So, thank you. Yes, so my question is with respect to requirements. Are there minimum requirements to qualify or to be selected as jailhouse lawyer?
So some prisons do have a minimum requirement. And so for the example, in the state of New York, we just partnered with the Department of Corrections and law students to actually redevelop their training and their standards because it wasn't sufficient. And what we've seen is that the institutions who aren't lawyers are the ones who are trying to decide what is sufficient. And that's where the advocacy of lawyers state by state, of naming what is sufficient resources, what is the standard of law, and also with the law students, that's one of the things that we are conscious of, where there is no official law clerk training program, then we're making sure that we're creating a program, and we use the PAR approach to be able to really understand, like, what are the legal issues, the culture inside of these states, to actually develop legal training programs like respective to that state. And then in places where we see that the training isn't adequate, we're redeveloping that training, retraining the law clerks in that space, but then also the law students are the ones who go in and do the training. So it looks different in each state, but it's through the research and relationship with the jailhouse lawyers that we're able to identify and then partner with the institution. And not every institution wants to partner. And so that is why we create the national modules based off what we're hearing from our inside members of what areas of the law that they need that they're working in but don't have knowledge and resources, we do send out the national modules that is equipped with the information, the knowledge, but also how to use it and how to advocate and shape and transform that area of law if there isn't a clear way forward.
Okay, thank you. Any other question? Please.
Good evening. Will it be possible to access the modules that you showed earlier from the Jailhouse Lawyers Initiative?
I'd be happy. I'm not sure how to share my contact or my email. I know there's people there that have it, but we will be happy to share all of our modules with anyone who'd be interested.
Okay, thank you.
Thank you very much.
welcome.
One other question from, yes, General Morales of the BJMP. Sorry, Bucor. Former.
Hi, Jody. Good evening. I just would like to know what is the most difficult challenge that your group has encountered in your work with the jailhouse lawyers?
The most difficult would be the ethics of jailhouse lawyering in the United States, because it's not really regulated outside of this constitutional practice. How people are using it's like an unregulated practice on the inside. And so really establishing our own ethics of what it means to be a jailhouse lawyer and trying to make that uniform and really, build this respect of the law, in addition to this strategy of using the law, but how can we build respect, and confidence inside of the law? So really developing an ethics of care around, and like a regulation, our own kind of regulation of the practice, I would think would be the most difficult. And the last thing I would say is to see the amount of experts who come home and can't use the law. We have law students that share the modules with their other classmates, and they'll give us the feedback that we wish our law professor was teaching the legal writing class the way that we read it here. Or I'll go into places, law schools, and teach the law, and to see this thirst that we're wanted in these places, and that we have this knowledge, but oftentimes just the lack of opportunity for us to be able to give it away to our own communities, I think is the hardest.
Thank you. Any other question? Okay. Yes, ma'am. Please.
Good evening, ma'am. I just want to ask, where do you get the funding for the training of these jailhouse lawyers, if there's any?
Beautiful question, because in the beginning, JLI has only been funded 2 times. And so this is an amazing opportunity for me to shout out. It is the work of law students over the years that have, when we say we have to have funding to get things started, it has truly been law students, and it has truly been our law schools that have filled in the gaps where there wasn't funding to do so. But we have only been funded like 2 times inside of the work, but it's mostly come through the efforts of our law students.
Okay. And then the last question. Jody, the assistance given by your organization, is it limited to those incarcerated in jails, or does it extend to those in prison?
So our work actually is rooted inside of prisons. And so that is the first place that we start. And so the jail, we are partnering with places like participatory defense to kind of connect those links between the pretrial and post-conviction. But we are mostly inside of the prison, because that's where the constitutional right, once you've been convicted, starts for us to be actually jailhouse lawyers.
Thank you. And may I ask the same question of Attorney Sadural? Does your work extend to also those in prison, or only those in jail, or both?
As of today, in jails.
Only in jails. And what's the reason for not extending it to those in prison already?
We still do not have partnership with the Bucor po.
With the Bucor, which is a good thing, because they are now here. Okay. Okay. So, thank you very much, Ms. Jody Polk and Attorney Jean Aubrey Ruby T. Sadural. Thank you very much for that very enlightening presentation and that wonderful reaction. And ladies and gentlemen, to your questions and the kind answers given. As we end, I'd like to give this message. Many people say that our jail and prison systems are broken and that they cause so many big problems, not only for those incarcerated and their families, but to the whole country. The solution, always in solving problems, is to focus on the problem, not to ignore the problem. As Justice Leonin said yesterday, shine a light, put a light on the PDL plight. The solution is not to lock up PDLs and forget them. Otherwise, more problems, bigger problems will arise. Crimes inside jail, prison will proliferate. The drug trade inside prison will flourish. Congestion, sickness, and death will follow. That's why the Justice Sector Coordinating Council has come together on the national level, and then the justice zones on the local level, all coming together to address common problems. But family of the PDLs and the public must come and visit and render assistance. Local officials must come and visit, not just the executive judge. After all, PDLs are part of the constituency of the local officials. And then again, DBM and Congress, Senate, must give the justice sector agencies the budget that they need. You know, ladies and gentlemen, the BJMP, the Bucor, the DOJ, the judiciary don't really get the budget that they are asking for. For the BJMP and the Bucor, forgive me if I'm stressing this because I am a budget person. Mostly, the budget goes to personnel service. Do sa salaries, di ba, ng mga employees. And then to the food of the PDLs, 70 pesos a day, or 4.7 billion for both every year. Always the funding is insufficient. Without the appropriate budget to hire the necessary personnel, the BJMP and the Bucor agency to PDI ratio, PDL ratio, will always be greatly lopsided in favor of so many PDLs per jail or prison guard. And because of the lack of BJMP or Bucor personnel, these agencies are constrained, mapipilitan, to rely on the assistance of the PDLs themselves to maintain order. Rely on PDL groups or sometimes gangs. And because of such reliance, special treatment at times is given to these groups. This practice spawns a host of other problems. Without capital outlay for new structures to house PDLs, our jails and prisons will always be congested. Remember, ladies and gentlemen, the budget given to the justice sector agencies is always insufficient. In fact, the judiciary, being the third branch of government, only gets just about 1% of the national budget, and it is the third branch of government. Without capital outlay for new structures to house PDLs, our jails and prisons will always be congested. No amount of relocating them to another penal colony or prison facility will suffice because these are also already congested. To really make a genuine, credible, meaningful contribution to decongest our jails and prisons, the DBM and Congress must give all justice sector agencies the budget they need to carry out their duties and serve the people. Again, good afternoon and maraming salamat po.
Maraming salamat po, Justice Carl Miranda, Associate Justice of the Sandigan Bayan. Your Honors, you are free to have your lunch. We will promptly start at 1 p.m. Please vacate po the center table because the Chief Justice will be back this afternoon, and also Justice Singh. So please, we will start at 1, and then we'll have a plenary session, then breakout, and then a closing program. Okay? Wala pong certificate yung hindi makatatapos ng lahat ng iyon. Maraming salamat po. Enjoy your lunch.